Mentioning.
My lord, I want leave for drop and complete of an order which was inadvertently.
May be permitted to mention, my lord, for leave to file an affidavit in support of a caveat in a testamentary matter delays of 1 day. Rule says 8 days. My lord, it was filed because of Saturday. There is a delay of 1 day. It has been affirmed. Leave.
My lord, may I be permitted to mention 2 probate applications for inclusion in the list?
25.
My lord, this is the 2015. PLAs of 2015.
No, PLA number 2050.
In pursuant to your lordship's leave, your lordship can remembers we have filed a caveat in pursuant to lordship's
Testamentary suit 7 of 17 and PLA number 169 of 25.
typographical mistake. It is
Correct it.
2015. I will, my lord. I will correct it.
My lord, may I be permitted to mention 2 probate applications for inclusion in the list? It's PLA 323.
Give it.
Thank you, ma'am.
After correction, my lord, leave me.
Origin side, item number 1 and 2. Such food products.
When the other matter is fixed.
21st, my lord. That's Monosha. The due reply, 21st. I start with Mr. Bachao to the comment.
Item number 2. It will just take, Lord, 1 minute. That Supreme Court matter, Lord, that got released on the last occasion. Now, Lord, I was praying, Lordship kindly keeps it, Lord, sometimes in May.
Who is your other side?
My lord, I am appearing for the award holder, my lord.
My lord, friend is there. This is the last order of the Supreme Court.
And this is the matter.
Tentatively, my lord, 15th April it's supposed to appear. So your lordship keeps it anytime in May, my lord. By then, my lord, I hope, hopefully, my lord,
Take to Judge
we'll get a hearing.
And to the benches.
All right. You say May.
Sometimes in May, Lord.
After vacation.
Whatever.
In view of pendency of the matter in the Supreme Court of India, hearing is adjourned to 11 June. Item number 3.
Item number 3. Miller, the mark in question is top gold and top gold star. Rolled up action for passing off an infringement. The plaintiff is using a combination of the mark, the top gold star, or the top gold. The top gold or the top gold. The top gold or top gold. Defendant is top gold star with star, Millard, is fleeting away, Millard. Is Millard just vanishing, Millard? Like Millard, we have Millard, those Millard vapors, Millard flying off, Millard. The mark in question is biscuit. Millard, I am holding the field in respect of this particular mark, where the evidence, Millard, has been, Millard, given by way of, Millard, affidavit, or Millard, by way of, Millard, the plain, which is an affidavit, from the year 2008 onwards. Admitted. Those documents are on record. Well, an friend hasn't said, Millard, these are fixed shares, false, etc. Even if it's a primarily prima facie stage, Millard, of an interim order. Said so. Millard, my learned friend Millard claims Millard to have used Millard this mark, not this mark, some mark called gold star and gold spot in respect
Your
of.
other side is here?
Yes, my learned gold star and gold spot. Gold spot Millard is Millard, the Millard aerated drinks Millard, like thumbs up. Previously, we
Yes,
have
we can
Millard.
remember our childhood days.
And Millard, the caps Millard, if you used to open Millard, the pictures of Mickey Mouse, Donald Duck used to come forward. So that was one of the charm of Gold Star, at least for me, Millard. Not for the taste, but for the pictures which I used to get. So Gold Star. This is not in relation to biscuits at all. Some Millard peppermints and Millard sweets in regal
Now, so far as these trademark issues are concerned, Section 27 is very clear.
very clear.
One is your statutory right,
And
another
one
is passing off.
passing.
Some differences are there in the enforcement of
Now,
both the
Millard,
rights.
now Millard, Supreme Court says Millard, passing off is a broader remedy.
Yes.
And if you cannot give any relief in respect of infringement of a trademark, court can fall back on the umbrella of passing off and grant a relief. The plaintiff and the defendants are trade rivals. It is a duty cast upon the defendant not to sell close to the plaintiff, not to sell close. If you don't try to do that, then your use or adoption is not malafide. It's not bona fide. It's malafide. Now, Millard, the defendant is a company, Millard, which is big, and the plaintiff is also big, Millard. They are, Millard, biscuit giants, Millard, after Britannia.
Now, so far as the registration is concerned, your privilege is top, you have no right.
Yes, yes,
So far as gold is concerned, top gold is concerned, you may have some right.
yes. It's in combination. If your lordship has a copy of the Trademark Act with your lordship, copy NHO. Copy NHO. Trademark Act at NHO. Lord, kindly have a lordship has it. So go with judgment to the NHO.
You're referring to?
Kindly have a look at whether, Millard, in combination, I can, Millard, come with the definition of the mark in question. Kindly have a look at the definition of mark, section 2M. A mark includes a device, brand, heading, label, ticket, name, signature, word, letter, numerical, shape of goods. Now, Millard, shape of goods, normally we used to know, Millard, that it is like a design or a patent, Millard, but it's also capable of being registered as a packaging or combination of color or any combination thereof. So, Millard, any combination can qualify as a trademark. A word can qualify as a trademark. If your lordship says, Millard, office of view, Millard, top gold, it's a combination of words. Top gold star is also a combination of. My learned friend's case, Millard, is that he was using, I'll show from the document, gold star in respect of peppermints, Millard, and top is generic. So, Millard, plaintiff cannot claim exclusivity by, Millard, combining the words top and gold and prevent the defendant from using the mark top gold star, because gold star he has been using in respect of peppermints in question. Millard, my case is, Millard, it would have been different if he has used.
So far as combination of color is concerned, it is not your headache.
No, combination of color.
It's
a
different.
Combination of what? Qualifying to have registrations, the trademark. Now, Millard, if your lordship now takes, Millard, one more, section 2H. These are very important. Section 2H.
Nearly resembles.
Yes. No, more than that. A mark shall be deemed to be deceptively similar.
Yes, deemed to be
another mark.
similar
Yes.
when it is nearly resembles.
Resemblance or likely to cause confusion or deception. So actual confusion and
No,
deception.
resembles in
Resemblance,
such a manner
yes,
that likely to cause deceive or confusion.
kindly, absolutely. That's the full section.
Because the word resembles is
Yes.
followed by this one.
Yes, so it has to be a resemblance. So lordship has to
And
see-
resemblance to that extent
yes,
which is likely to deceive
and cause confusion.
or cause
Likely.
confusion.
So resemblance likely to deceive and cause confusion. That is the test of deceptively similar, because the mark in question here is top gold, addition of star. So lordship has to take it whether, Millard, top gold,
So your argument is that this is deceptively similar.
deceptively similar under section 2H. I have come forward and got an order of injunction. So this is, Millard, on, Millard, the action in question. Now, Millard, kindly have a look at the vacating application of the defendant. Kindly have a look at the vacating application.
Mr. Ghosh, one thing I just said vacating application. I remember one thing. In the other matter, the vacating application is not before me.
Very well. I'll ensure that
Check it.
That's
I have checked it.
I'll definitely.
Otherwise, it will call confusion. It will call problem.
Absolutely. Well, I'll definitely do. I'll definitely. Lordship has said, Millard, I'll definitely. Kindly have a look at is Millard.
Vacating application is
Vacating application is GA
Yes,
com number
three.
3 of 20.
3.
Kindly have a look at the vacating application in question. Millard, my entire petition is NA. So Millard, I am Mr. Bachawat was showing it. Now Millard, kindly if your Lordship takes the vacating application, Millard, if your Lordship takes Millard his defense in question, plaint is set out. Paragraph 7, page 11. The plaint part I am just omitting. That's his defense. 1, 2 paragraphs I'll only read.
The facts relate to
Yes. Facts relate to use of the mark gold star along with the top gold, which the word top,
along with the word top.
which is used commonly in trade of biscuits. So his case is Millard that gold star is there and top is common Millard for the purpose of biscuits. Now Millard, if the mark is common in trade or generic, then why did you apply? Why did you appropriate it for Millard the biscuits or try to appropriate for the biscuit? You are also using it as a trademark. It's not a case, Millard, that you are Millard not using it as a trademark, or you are not describing as the character of the product in question, or is the character of biscuits in the question. Now, Millard, Lordship knows Millard top has nothing to do with biscuits. We may call it top biscuit, but that's a mark. Like for slippers, Millard, we say Hawaii choti. Now, Hawaii is not it's a rubber slipper. Millard, Hawaii is a trademark. We call it Millard, it's a top biscuit. But Millard, the top are Millard registrable as a trademark under the act in question. So his case first, Millard, top is common to trade in biscuit and confectionaries, is common to trade defendant with the predominant mark of the defendant being gold star. On their product, the word top gold as a whole, nor any mark similar thereto has been used in any manner at any point of time by the defendant. So he says, Millard, I am distinguishing my product by using the mark star. I have not used the mark top gold as a whole or nor other similar mark. So whether it's a mark is similar phonetically, visually, Millard, it's a Millard test of the eye, Millard, of not Millard, me, Millard. It's Millard the test of average customer with imperfect recollection, Millard. And Lordship has to test it, Millard. As Millard sitting in the Millard chair, not of an honorable judge of this court having commercial determination, but Millard as a test, Millard, whether Millard top gold star and top gold are deceptively similar, are average customer with imperfect recollection. So this is the test. Even in cases, Millard, where packets are not similar in question, like the color combination, courts have gone forward to give protection to marks, we call it in legal parlance, Millard, generic mark, like handsome. Handsome, in respect of fairness claims. Courts have protected. Though, Millard, the plaintiff was using fair and handsome, the defendant was using glow and handsome, or Millard, some other marks in question. Injunctions have granted on the mark handsome in question. If I can show, Millard, that is a duty cast upon the defendant, Millard, along with the test of deceptivity, Millard, not to sell clothes. So this is his case here. Now, Millard, kindly take Millard the next one. The defendant at all
likely to cause confusion.
Resemblance and likely to cause as aptly put forward by Millard. Now, Millard, kindly take the defendant at all material point of time has
Mr. Ghosh, there is one judgment, very old judgment under 1940 Act.
Yes.
Ashok Kumar Rokhit, Sri Ghi. Even there be disclaimer.
Yes.
That may not be infringement.
But under the umbrella of passing of Millard, you can
Yes,
it's a
it will come.
judge. It's a three.
Even though there is a disclaimer.
Three keys case, Millard, because the market, Millard, or the consumers or the people in the market are not privy to, Millard, the certificates in question. They are not advocates or trademark attorneys.
Right.
They don't know, Millard, whether there is a disclaimer or no disclaimer.
What rings in the ear?
What rings in their ear? So even if I cannot succeed in the claim for passing infringement, I can, of course, Millard, fall back on the broad umbrella of passing up. Now, we'll kindly look at his explanation, what he has given. This is very important. The defendant at all material point of time has been using the mark Gold Star, which the mark was used by the defendant for confectionery products, so not for biscuits, which was allied and cognate. So, same and similar both since 1931. So, it's a statement on oath. The trademark Gold Star of the defendant is a well-known trademark and is acknowledged worldwide in 1931. Various journals and other printing, various marketing prints have acknowledged Gold Stars used by the defendant in confectionery products, which is an allied product of biscuits since 1931. Such recognition and distinctiveness of the mark Gold Star has led to the adoption of mark Gold Spot for beverages by the defendant. Such adaptation has been recognized in market survey and other third party. So the case is what? Gold Star. So you do Gold Star. Why prefix it with star, top? If at all. Now, that is also not coming out from the documents disclosed in the petition. Kindly have a look at the petition in question, the second volume. If your lordship takes vacating second volume, the first volume is my petition.
Second volume, page.
Annexure D, page 230. Now, this is a page which is available in the internet, of which printout has been taken on 12th of August 2024 of one lady called Surabhi Kedia. Surabhi Kedia. Now, kindly take what she is writing. Kindly have a look at the next page, page number 232. I will try to be very short with the documents. In the year 1928, anyone can write it, Millard. It's a question, Millard, whether you are giving Millard a date in question. Millard, I can go in internet, in Wikipedia, and I can write documents in questions. In the year 1928, witnessed the foundation of the brand when Mohanlal Daniel founded the House of Parle. Following year, Parle factory started its marketing production with confectionaries Gold Star and peppermint Parle G shown. Now, Lordship will kindly take 1972. Now, Millard, hide and seek is 2008, page number 233. Now, kindly take, Millard. This is an article which has come out. Millard, date of the article, you will not find, Millard, subject to correction, Millard. Millard, any Millard, date in the question, particle in question. Now, Millard, its success story, which starts, Millard, at the article, which is printout is taken, Millard. From Millard, it's Millard, 12th of August 2024.
Which page you're referring to?
Millard, page number 230, Annexure D.
Yes, that Jani Survikedia.
Wikipedia, it Millard, the document Millard do not bear any date. It's a writing Millard on the internet. The document was taken out on 12th of August 2024 at 11:45 AM. Now, Millard, if there is a book which Millard says Millard that this article was there. Normal Millard in textbook, if I say Millard, it's published in which year? Written. Reprint in which year, Millard? Written. It's there. Unfortunately, this document is conspicuously silent. Mere writing in internet, Millard, of something, Millard, doesn't, Millard, make it a user, Millard, by one Surabhi Kedia. Now, Millard, kindly have a look at page number 238 in question. It's a case study of Parle Products, Journal of Budget Brand towards premiumization. Now, Millard, kindly take, Millard, page number 238. Millard, this is, Millard, published in the year 2020 by K.J. Somia, Institute of Management, Bombay. So, Millard, it is also not prior because this article itself, Millard, has been published. The article may have a journey of Parle, Millard, from 1929. But these are not user documents in question. That's page 238, Business Perspective and Research, 2020, K.J. Somia, page 238, refers to Parle Industries from 1929. Kindly have 239. I'm trying to be very short in question, Millard. Very short. Page 239. Millard, kindly take Indian Biscuit Industries, a profile, the middle portion. Parle Gluco 1938. That they are writing. 239, Indian Biscuits Industry, Millard, 1, 2, 3, 4, 5, 6, 7, 8 lines from Millard, that heading Millard. Then Millard in India, 240, there's a market survey. Yes, to us. One paragraph. No, you see now, page number 240, there's a table. Market share in the biscuit industry 2018. Britannia industry 30.4, Parle 28.6, Saj 3.1. That is a market survey, Millard. Now, Millard, Lordship will omit that. Kindly take page 242. Parle, the mark appears. I have no dispute on Parle. Parle is a big brand, Millard. Now, 244. Page 244. Has Lordship found 244? Millard, table 4. Brand biscuits. Serial number 1, Parle G. Crackjack Extra Extra. Then Millard in the bottom, Parle Gold Star. Millard, Millard, second line. Top.
Table 5.
Yes, table number 4.
Oh, okay. Parle Gold Star, yes.
Parle Gold Star. Now, Millard, the author writes in table number 5, Parle factory started with confectionery Gold Star, mint and peppermint. So, Millard, it's on Gold Star. Now, Millard, kindly now have source 245 is the author himself. Page 245, just above table, just above table 5, and Millard, table 4, source is the author himself. Table 4 and table 5, the source are author himself. Yes, yes, you can go. Judgment গুলো বিশ্ব একজনকে কাউকে পাঠিয়ে দাও। ঠিক আছে, তুমি যাও, তুমি করে এসো। Now, Millard, kindly take 247. Parle products price range. Table number 7. This is there. Lordship will not find the present, this is the present biscuit range, Millard, which Millard, the author is writing. Hide and seek range, Milano range, Nutri Crunch range.
Yes, these are there.
These are there. Lordship will not find, Millard, that Gold Star, Millard, story, Millard. Now, Millard, kindly, I am trying to, Millard, speed up. Kindly now have, everything is there. Now, kindly take, Bisc Farm is also there. So, Millard, it's a table, Millard, which party or which, Millard, proprietor is doing what. Now, Parle's table, Lordship will find, Parle may have a band, this doubtful. Table number 7 is Parle products price range. Page 247. Page 247 is Parle.
Basically, they're relying upon some articles.
Article. Millard, kindly, Millard, I am relying on their article. Kindly have a look at 247. Table number 7. What are the products of Parle? Hide and seek, Milano, Nutri range.
This is not there.
This is not there. Now, Millard, kindly come to the same article which they rely upon, the Bisc Farm table at 253.
253.
253. Bisc Farm biscuits, brands, price range. Serial number 9, 10, 11.
Top Gold.
The top gold, top herbs. Millard, doesn't Millard, his claim for prior user, Millard, fall flat on his documents?
So according to you, even if we rely on their documents,
First
this
of
is
all,
admitted
Millard,
position.
First of all, Millard, is for the purpose of prior user, Millard, one has to, Millard, source is only the author. The author relies on several links. There is too high, Millard, connection, too higher test on the basis of connection sought to be established. Takes to 181, page number 181. Source is author. if I take the author's source to be sacrosanct, then this biscuit range top gold star is absent.
Should we take it so?
It's absent. It's absent, I take the best argument case. Though it's not 260 will roll out. Kindly take 260 Millard with me. 260. If I take his best argument, normally Millard, in matters Millard, we say Millard, in some matters in commercial jurisdiction, the best arguments case for assessing damages. As Lordship knows. 260, last line, it's a PDF Millard created in 2016. Bottom, Nielsen report is 2016. The one date coming, only one date is coming from those documents. Last line, www.
Nielsen, yes.
Nielsen Millard causes market survey. Causes market survey.
In 2016.
2016, I am in 2008. Now Millard kindly takes Millard one more document, then I go to the law straight away. Millard 261, as I told Millard, gold spot, Coca-Cola Millard, or Millard, I have Cola War, no dispute. Indian brands Millard, taken away Millard by the foreign brands Millard. Now Millard, kindly take Millard 263. 263.
Yes, Ancola.
Gold spot, the Ancola which had a zinc. So first of all, Millard, gold spot is not relatable to biscuits. Gold star, according to him, also not relatable to biscuits, but he has used this for confectionery. But the question is whether he has used top gold star in combination. Or the document is blown out. The unfortunately answer is nothing. There are Wikipedia printouts which have been taken. The first doesn't have a date. The second document has been created in the year 2021, which relies on a document of 2016. Page 200 and 260, Nielsen's report. Millard, if someone is a prior user, what is the defense? Lordship has heard now Millard substantial trademark. I'll come back to the look. This firm is prior user as against Millard Britannia in respect of a mark. I come to court, I throw the advertisement and the bills to the court or file it by way of a finished. That's the end of the matter. Why I take Millard, this Millard roundabout route, what happened in Gold Spot, what happened Gold Star, Wikipedia page, etc., etc. If I am the prior user Millard, I must have prior, if it's a goods Millard which are covered by excise under the Excise Act, I will have excise bills, cigarettes, tobaccos. The bills are Millard, have to be Millard excise challans. If there is a FMG goods Millard, there will be stock register. Forget that Millard. There will be advertisement in the open market. Parle Gold Star biscuits. Parle Top Gold Star biscuits. Do I need to Millard show Millard Pura Bicadia, then Millard some other article, then Millard other article?
What people understand, what people perceive, that is the most important question. Consumers.
Document. How do I prove user in court? By way of bills, by way of invoice, by way of advertisement. I'll show what advertisement they rely upon. Kindly have a look at 263 Millard of the vacating. 263 of the vacating in question. This is Millard posted by one Vijay Anand. Millard, we do not know the credibility of these persons in question. On 25th January 2023, page number 263. How can you dislodge my claim, Millard, on the writing of article on Gold Spot, Millard? This were there in 1940. Kindly now have a look at page 264, the Gold Spot Cola, and 265. It's an article published in 2023. Parle, though, was not kind to give up on its gold so quickly. Gold Spot, a carbonated orange drink, was instituted in 1952 and named after the company's successful Parle Gold Star peppermint product. Where is Top Gold Star? The Gold Star also someone is writing in 2023. Millard, if I start writing Millard a book in 2023 on an article that Mr. Obijit Sarkar had used Britannia since the year 1800, will it be a case of prior user? and the source is Devnath Ghosh himself. Would I go in the box and give evidence?
All right, got your point.
Now just I end the vacating part. So next day I straight away go to the law. Kindly, Millard, have a look at just few paragraphs. I will not, Millard. Millard, 268, new gold spot in the bottom.
Page 268.
Yes, I don't, Millard. Next day I come and picture. 268, new gold spot. I'll show Millard his document. Then Millard, kindly have a look at page numbers. I have made my so that I don't read the entire petition. 269, new gold spot. Also, Millard, carbonated drinks, Millard.
So your point is, although they're harping on this new gold spot and so,
Yes.
not related to biscuit.
Where is the document for the now prior user is a question of fact. Passing off is a question of fact. If there is a question of fact, we are in the ad interim stage. You have to bring on unimpeachable documents showing that you used this mark from a particular date. Advertisement in newspapers. No one can doubt that. If not, some sort of invoice and bills. Now, will that kindly take 272? This is an admitted position. How does it give him the prior user of this recording reports? Parle sold out to Coke for $40 million when the cola war resumed in full force. Introduction of Pepsi in 1990 and return of cola in 1993. Coca-Cola pulled out the plug on the coldware. So we all know it. Now, Millard, kindly 274 Indian soft drinks. Now, most important, if a mark, that's Mr. Bachawat has indicated, Millard, my leader, Millard, that Millard, if a mark has been discontinued from being used, can a claim of prior user be raised? The documents disclosed by my learned friend in the petition itself. If you take page 275, page 275, gold spot. This is very important, Millard. I'll cite a judgment on this. Introduced in the Indian market in 1954-52, gold spot was one of the most popular soft drinks in the country for a while. Millard, biscuits and soft drinks are not cognates or allied goods. Millard. Yes, by the way, at the time of consuming biscuits, Millard, the biscuit may stuck my throat. I may have a Coca-Cola, but though that doesn't mean, Millard, it's a cognate goods. Cognate goods is what? Toothpaste, toothbrush, both have to be used, Millard, together. Toothpaste, toothbrush, shaving cream, shaving brush. These are cognate goods. Or the shaving foam, after-shave lotion. Now, Millard, kindly take, Millard. The orange flavored drink was carbonated soft drink manufactured by Parle, led Ramesh Chauhan, earlier named Gluco-Cola. Parle had to change the name after Coca-Cola entered to the name. Gold Spot was later named a famous gold company called Parle Gold Star. However, with the introduction of brand Coca-Cola India market, the demand for Gold Spot eventually declined and it was discontinued in the year 2000. Now, if it is discontinued, you are no more in the field. Can you claim any residuary goodwill on that, on your document? First of all, this is a document published in 2023. Author, Millard, is the source is giving. Now, Millard, that's not sacrosanct. I may write a book. I may write 30 things, Millard. That's not sacrosanct. Unless, Millard, the books are, Millard, like Millard.
What is the ground reality? That is your question.
Yes. Like, Millard, the books like German and Will Millard. Will cite that as an authority. So anyone and everyone, Millard, cannot write a book. Now, Millard, kindly, or Millard.
Come on the next two judgments. The points of law.
Just, Millard, 2 pages left. I'll just cite and go to the judgment. I have prepared a compilation. I'll just cite the paragraphs now, as I normally do. Any date lordship gives to. Judge Sahib, পরের দিন শুনবে আজ আসবো।
You have to reply.
No, I have not completed the
Come with the notes of argument or your judgments next day.
Yes, I'll do that. Millard, he's asking for.
It's not completed on facts also.
একটু শেষ করবো।
It's not completed on facts.
Any date you lordship gives me, I am not standing.
Date bolo.
Except me lord 2 days in next week.
No, no, not, of course not. 21 থেকে 25 দেখো কি আছে।
তোমরা কোথায় আমার
অথবা 28, 29, 30। 25 is okay?
My lord,
to me it's okay.
my lord, I'm also not there. My lord, Mr. Mukherjee is also not there. My lord, if your lordship kindly keeps it on 7th or 8th, my lord,
May?
Then we spill over after vacation. That's the
because
problem.
I'm in a little bit of a difficulty on. No, no, no. যাবে না।
যাবে?
My lord, I'm in a little difficulty, my lord, on 6th. That is the only difficulty.
28, 29, 30 April?
দেখো না, 29th April.
29th April.
I'm here.
May will be too far.
29. Great. Much okay.
Interim order is there.
Interim order till still today.
Hard Mr. Ghosh in part. Adjourned to 29th April. And interim order is extended till date.
Grateful.
My lord, it is specially assigned, so in part is not required.
Especially assigned.
Specially assigned.
That's already lordship.
No, let this be mentioned. I have not finished Mr. Ghosh. I'm giving a scope for come again. That's why inside part hard.
It's always a pleasure, Milord. Great.
And you check the other thing
Other thing I'll check and intimate one.
because this will not be correct thing. Ideally, both should be taken up together.
Absolutely. Absolutely. I'll just check.
And I have heard your injunction application substantially. Now neither can I backtrack nor can I reject.
Yes. No, no. I'll get that. Milord, that will be there because vacating is in effect an opposition.
The same thing.
Same thing, same. Line to line is same. Grateful. Great. Now,
Item number 4.
Might please, Milord. Milord, I am appearing for the plaintiff in item number 4, Milord. GA8 is an application that has come up at the instance of Milord defendant number 1, seeking Milord transfer of the suit from commercial division, Milord, to the regular division, Milord. Milord, we have already filed our affidavit in opposition, Milord. We have received the affidavit in reply filed by the plaintiff.
This is a commercial. It is right now. It is a commercial division.
My lord, my lord.
So I think I should release this matter because the commercial. I have no determination for commercial matter. You place
My
before
lord.
the commercial bench.
My lord, in fact, my lord, the suit was transferred by a lordship's order dated 1st March, my lord.
So let
So
it
right
be
now,
placed
Yes,
before the
Milord.
commercial division.
my lord, my lord.
The matter is released from this court since it's a commercial dispute. Since it's a commercial suit, to be placed before bench having determination.
Grateful, my lord.
Mr. Bosch, I was talking to Mr. Ghosh last day.
Yes. No, it cannot be released under because the notification of May 2023, you can see the notification, says that it should not be released. One. Second is.
Why should not be released?
My lord, it is number one, it's a part-heard matter. It will not be released. Notes of argument were supposed to be filed. We did file. All that was remaining was to pass. It was made CAV.
Not CAV, pass for order.
Judgment.
Not judgment.
Then it was taken up for hearing one day.
For order.
Your lordship said, I will send it to the collector. That is the only question why it was. So we filed another supplementary and it was on the last occasion.
But once I pass any order, whatever that order might be, it will be released.
Yeah, of course. Well, I am obliged. It will be released. I say that is
Suit is not part, one day the matter.
Suit is not part heard.
Yes, and this is just an object.
I
That's a simple
agree.
point.
Either
Even your other document,
no
why-
application.
which-
So what can be before my lord part heard? Only the suit, but your lordship.
not suit, actually the argument, the production of particular document, tendering of particular
Between
document.
two questions, this objection happened and now we are hearing it.
pursuant to your lordship's order.
But I think, like, since it fell from my lord, I'm not picking and choose. I'm happy to do it here. But my lord, it's a commercial matter. It will go there. The suit
Right.
will continue.
There's an exception.
Because there is no application before
There's
me.
no
May
application. that
not
will
be a
part heard.
application, this aspect for which is going because your lordship.
All right,
passed
when
an
I have
order.
kept it part heard, let me reserve it for order. I will pass order.
To make submission, my learned friend has given new decisions on the last day. Then your lordship will hear me.
No, you wanted to file a supplement. That is why.
You want to file notes of argument, you can do that.
As far as the distinguishing the cases, then I'll file a note. I'll file the note, or
How
I'll
long would
come
you
back
take?
with my note. And
How long would you take?
but my
Na-
learned
next
friend
week is
has
almost
cited
holiday.
1, 2, 3, 5 new decisions.
No,
with
next week
help
is
of my
almost
lord.
holiday. So
Yes,
after the reopening,
Yes,
Given
yes,
law.
anything.
22nd April.
Very well.
What can I say?
22nd.
It was last day, no one was there. Then he picked me.
In fact, I'm feeling little uneasy passing this order since I have no determination on this matter. First thing, second
This
thing.
cannot be, your lordship.
It's not-
Kailash, imagine the number of days of
I
this
understand
issue.
that agony. I
Well,
understand.
That is why the part had. Otherwise, it has no meaning. I mean, not because next day probably.
Because that
what is
will cause
point
an
is-
agony to your client.
Probably you won't find me because the client, some junior will come. All they have to do is to file
There is another suit relating to the next property, the second floor. Same parties. That is before the commercial bench now. Now there'll be.
So
two
let this.
different-
I am passing. I will come with the argument. I will pass this order and I will release it.
that I think, Millard, proprietary demand.
Because I have heard you.
You should.
I understand your agony now. You have made a substantial argument.
And as far as what
But so far as the other document which you said, which has already been admitted, that I will not hear. Because in course of tendering this document, I will hear only this one.
the signature, I'll tell my lord briefly. I'll come
The
back. on-
signature was also subject to
Yes,
objection.
that objection will
That
be
I will not
heard.
pass because at the time of tendering this document, these points were raised.
Yes.
So I will pass this order
Yes.
because I have raised this objection.
Yes.
So far as other documents are concerned, you place
No,
before.
why? How can your lordship? Only with respect to I have raised with objection.
Right.
Naturally.
I'm applying my judicial mind for that to that
Yes,
objection. This
That
much.
is because your lordship passed the order.
Mr. Bose permits me. my lord. Your
Of
lordship,
course, I'm sorry.
your lordship, there is the documents were, the signatures were proved. That's exhibit 1 and 4, which are subject to
Which one?
objection. In this matter, on that
No,
same
which document you are referring to? Which is tendered?
the MOU and the agreement for sale.
Which is tendered?
Yes, it was tendered. The signature has been proved, but the document was not allowed to go in.
Yes.
Now the signature has gone as subject to objection. Now after that, many questions have been asked. That objection will be heard at the time of
Come
argument.
on the next day, I will check it.
It will be heard at the time of argument. So what my contention will be before my lord is, even this, it should be exhibited subject to
When
objection.
Mr. Ghosh, when I've heard this, let me
Yes,
apply
I'll
my
come
mind
back.
to the arguments.
Yes,
I will
come
pass
back.
order, necessary order.
Because your lordship
Whether
has-
should I defer this thing or I should pass any order, that after taking
No,
into
I'm
consideration.
the merits, I'll argue the matter. As far as this objection is concerned, I'll argue the matter since your lordship had suggested us to read one decision, 1961 Supreme Court. So I'll make my submissions on that. My learned friend has included all of them in his notes.
All right.
And if I
That
can
Praj
come back,
Surana, 61.
yes.
That
But
has been considered in 1978, Pankraj Naki
no, in
Pankraj.
2024 also, my learned. There's no,
No, Ramratan something.
Pankraj Naki, 78 Supreme Court.
Ramratan.
Namratan is 61, I think.
Ramratan 78.
Oh, sorry, Ramratan.
Praj Surana 61.
those cases, I'll come back. I'll come back and tell.
Come back.
Yes.
No, why don't you file it was on the last occasion, lordship get time to just file a.
Don't understand. There's 6 new decisions I'll want to
This
deal
was
with
given-
them.
All right. Come on 22nd, I will pass order.
Lordship is seeing something. Lordship has Lordship's notes there. I thought Lordship must be having a tablet or iPad there. Lordship is looking at immediately.
I am not familiar with iTab. iPad on these things.
My 22nd, my learned friend has some problem.
23rd. All right.
20, I'm great.
Maybe get a copy of the additional
Yes, you can give an advance copy.
at all. Rely. Because they said, your lordship, on the last occasion you weren't there, said you will file it by Friday. It's ready. He said it is ready with me. That's what I mean told. I'm true. Great. But, if next day, Miller, I'm not there, please, because
When will be there?
it's not a question of
for this part. I will be there in the minor part.
There is another 3-4 days we must have.
No, I want to finish it, Mr. Ghosh, because this is a case of embarrassment for me.
Item number 7.
This is the most sound point, sound argument. This is embarrassing for me.
My lord, we are enjoying it.
Item number?
7, my lord.
Yes.
Well, the undefended suit, my lord. My lord, the matter had appeared on 4th of April when I had taken an adjournment because my witness my lord, could not come. My lord, I at that time thought my witness will not be able to come. I'll figure out something else. I have been informed, my lord, that the witness, she can't come, but the commission can be done. I have his, my lord, he's suffering, my lord. He's got a kidney ailment. So, my lord, he's
Have
going
you filed
through
any
dialysis.
application?
I have not filed any application, my lord. I was praying, my lord, if under Order 26, Rule 2, on your lordship's motion, my lord, if it can be done. Because the urgency I have, my lord, is he's
You come
hearing-
with an application stating all these ailments. Otherwise, what shall be the ground?
my lord, my only
That will
difficulty-
create bad precedents. I'm telling you, that will create bad precedents. The court will be jumping into you, taking assisting you, and all these things will come up. So file an application, giving that he is an ailing person.
I'll do that as soon as possible, my lord.
I am adjourning it till first week of May.
My lord, if your lordship keeps it on 21st only, or 21st of April, I'll come on 21st
On
of
prayer of
April.
Mr. Mukherjee, the suit is adjourned to 21st April.
Yes, my lord, 21st April.
21st
Because, my lord,
April.
witness is there only till 30th of April, then he's going to Bombay. So I would want to do it before that. If it's
Even you can do it on 16th or 17th.
16, 17 the parliament application the file code.
Once you file an application, I will pass order then and there. It's
I'll
uncontested.
try filing it immediately, my lord. Immediately.
Adjourned to 21st April with liberty to mention.
I'm obliged.
Item number 8.
Why this execution case is before me?
Yes, because it's an urgent determination of my lord, this is Bishwarup Chaudhary. We had mentioned for inclusion. Your lordship is
My lord,
this
there
is
is-
within 2 years. So
No, there is a
technically they were not
There is a
required.
division bench order, my lord, in my appeal, my lord, by which my lord, Honorable Justice Showmenson's division bench has, my lord, appointed a retired honorable judge of our High Court for the purpose of, my lord, mediating the dispute. It's really, my lord, quantum of mean profit that my learned friend is pressing for in execution. My lord, the order says, my lord, that the party shall take steps, my lord.
But they have
This
not
time
taken
has
any
not
steps.
yet.
Just a minute, one by one. Let me understand what this application is.
Yes, there's an execution application of a decree for mean profit, which was passed by your lordship, my lord. Kindly takes a look at, my lord, page 13 of my application. My lord, suit for eviction and
Tell
mean
me
profit.
what is the urgency in the matter? In moving this execution petition.
My lord, there are huge outstanding corporation
Right.
cases which
But
are
is there any impending problem? What is the urgency? I understand it's pending, but
Yes.
this is for a very limited time till 11th, I think. So after 11th, you can move it.
Even possibly the
Only
next
till
week
this
also.
week, my lord. Next week, possibly 17, Justice Chaudhary is back. And in any event,
Yes.
because of the division bench order, my lord, the time to complete the mediation is also not over, my lord.
No, let them only may I only humbly seek one order, my lord, subject to what falls from your lordship. My lord, let them file an affidavit of assets. My lord, in the meantime,
These are regular matter placed before the regular bench. If you need any urgent relief, like injunction, like attachment, all these things,
but
I can.
I would be otherwise praying for an injunction on the bank accounts.
No, my lord, I'm the
Because
opposite.
I-
It's not
I-
urgent,
the
my lord.
regular
They have
bench.
waited for so much time. They
There
can
is
wait
there
for
is
2
no
more
stay.
days.
There is no stay.
Right.
On
The
the
matter may be placed before the regular bench.
Grateful, man.
Item number 9 and 10. Marlin Project Limited.
Sir, you are plaintiff or defendant? Marlin,
My lord, on the last occasion,
who is the defendant? You are.
scared of.
Why scared of?
Now, on the last occasion, my lord, I pointed out that there is an application made by the plaintiff for amendment of the plaint on the ground, my lord, that, my lord, after the filing of the suit, the defendant had changed its address. So, my lord, the address given in the cost.
অ্যাপ্লিকেশনটা কোথায়?
That is, my lord, GA5. Now, after GA5 was taken out, my lord, lordship need not look into that. It a service check. After it was, my lord, taken out, then, my lord, it came to my client's notice that the defendant has again changed its address.
So you have to withdraw this.
No, on the last occasion, I pointed it out. Your lordship said, my lord, or my lord, I submitted before your lordship. Your lordship was pleased to observe that, my lord, I shall file a supplementary affidavit, my lord, giving, my lord, the new address and, my lord, the proposed amended plaint. Kindly come to page 5, my lord. My lord, that is the, my lord, MCA portal.
32 Jawaharlal Nehru Road.
Yes. Now,
This is new address.
this is the, yes, this is the new address. Now, kindly come to. It a running page দেওয়া আছে তো? না, না.
So this change will be according to page 4.
Yes, kindly come to, my lord, page 7, 8, 9, 10 possibly. Internal page 4 of the plaint, my lord.
Yes, it's there. Any other change?
No, this is it.
Verification
And the verification affirmation, my lord, that is.
internal page 26.
Cute. না না আমি এটা হিসেব করে রানিং পেজটা হিসেব করছিলাম
Any objection?
It's like it can be that not by record. Advocate on record can sign in.
and page 26 kindly come to, my lord, that's the re-verification.
Yes.
26 and
GA5
20.
of 23 is filed by the plaintiff. Oh, the first amendment was 8th floor Circus Avenue.
It was not carried out.
No, it was not carried out. Pending this, another change address was there.
Yeah.
Praying for amendment of plaint in view of change of address of the defendant. Full stop. The proposed amended plaint delineated with red ink is annexed to the application.
My lord, to the supplementary affidavit.
No,
I'm sorry.
to the application. I have to make clear that this should be ignored
Lordship. I'm sorry.
and supplementary affidavit is to be relied
Yes,
upon.
yes, I'm sorry.
8th floor, কি বললাম? Application. Full stop. Pending this application, there is a further change of address, registered address of the defendant.
Oh,
Full stop. To bring the same in the record, a supplementary affidavit is filed on behalf of the plaintiff. The proposed amendments are now annexed to the supplementary affidavit
as annexure X there too.
as annexure
X there.
Annexure X. Proposed amendment are underlined with red ink. Full stop. Next paragraph, Mr. Dotto, the learned senior counsel, and Mr. Shen, the learned senior counsel, appearing for the defendant, did not raise any objection. Prayer A to E of the master summons accordingly is allowed. The department shall carry out amendments in terms of the proposed amendment annexed to the supplementary affidavit and not to, ওটাকে underline করে দেবে, not to the application itself, since that proposed amendment has now been infractuous.
Oh,
That's why I have to explain these
yes.
things.
I'm obliged. I'm sorry, my lord, for interrupting.
When will you come?
My lord, kindly fix a time, my lord, for carrying out the amendment and
The amendment shall be. Let me fix a short date for further order.
Sorry.
Let me fix a short date.
That GA5 is.
The suit will appear in the list on G5 of 23 stands disposed of. The suit will appear in the list on 21st April for further order. Hopefully, it will be done in the meantime.
next week, my lord, we have only 2 days. That's it.
No, 21st April,
So next week. we have-
28 April.
Yes, my
Milord, so far as GF4 is concerned, Milord, GF4
সেটা কি?
GF5.
একদিনের জন্য করবি না।
GA1.
GA1. Milord, that has nothing to do with this. That can be taken up for you.
G1 is for injunction.
That, Milord, because, Milord, I am suffering an order of injunction, Milord. At least, Milord, on the last occasion, my learned friend had assured your lordship that.
So GA1 means ad interim order was passed. No vacating in application.
No, it went up to Supreme Court. They went up to Supreme Court.
The question of commercial suit, whether it's a commercial suit or not. But that's not the point now. Now on merits, Milord, we have affidavits and exchange, Milord. Kindly, Milord, ask my learned.
কবে date বললো? So 28 I am fixing for hearing GA1.
No, Milord, let me at least start, Milord, let get a hang of what the matter is about, Milord. Because, Milord, this is probably the 7th or 8th time when which, Milord, this GA1 is. Milord, the interim order, Milord, which I am suffering, Milord, he is enjoying an order of injunction in respect of a plot of land, Milord, of which, Milord, he has no right. According to me, of course.
All right. That you may say always. Not to create third party rights.
Yes.
This is your application.
Yes.
And, Milord, as on the date of, Milord, this order was passed, Milord. As on the date when this order was passed, Milord, I had brought it to the notice of the court that the property has there is already an. Kindly change the order once, Milord. Page 8. Page 8 of the order. First June 2026, Milord, was passed by. Noticing the vacation, Milord.
Where's June? Where's June order is not here? Oh, it was in vacation bench.
But kindly, Milord, come to. Milord, whether the learned judge was right in the only thing is which is troubling me is, Milord, page 8.
এই অর্ডারের কপি রাখো একটা রেকর্ডে। এখানে 21st জুন তো 21st জুনের নিচে 1st জুনের অর্ডারটা রাখো, এখানে অর্ডারটাকে রাখো।
21st জুনের order? 21st জুনের কি অর্ডার আছে? জজে বললেন 21st জুনের নিচে ফাইল শুনরা।
This is at the instance of the plaintiff.
GA1, yes. My suit for specific performance in that application for injunction and the interim order of injunction was drafted.
Thereafter, Milord, the entire dispute took a turn as to whether it's a commercial dispute or not. Milord, and Milord, the parties went on. But what is right?
It's drifted away from the focal point.
Kindly come to
Suit was drifted away from the focal point. That is the injunction.
They did it. I did
So
not.
at least there is a basic on principle that the suit got delayed. Milord, page 8, Milord,
Of
that order. Milord.
vacation bench passed a very big order.
Yes, had to. They argued. My learned friends were not there.
Kindly see, Milord, page
My
8.
learned friends were not there. They argued for 1.5 hours, man. I was there. I got opportunity, my lord, to speak maybe for 15-20 minutes, my lord. And my lord, then the order was passed. Chota pota pore.
Milord,
6.
In the evening, my lord. They started arguing from 4.
was your suit. Anyway. The penultimate paragraph at page 8.
Mr. Shah produces. Development agreement has already been entered into a third party.
The registered. But anyway, development agreement registered. Mr. Mitra had objected.
First, there was MU.
There was only Milord. If I may be permitted, Milord, there was only Milord.
Rosh, we'll hear out the application on any day.
There was MOU.
No, no.
Term sheet, sorry. Term sheet. Term sheet was termed as void.
Yes, the term sheet said that these are the broad guidelines on the basis of which we will enter into a gen development agreement. The term sheet rested there. Thereafter, a payment was made in terms of the term sheet, and thereafter the agreement was terminated and money was refunded. And till date, the refund. So, Millard, according to us, Millard, and thereafter there has been a subsequent development. Millard. Now, Millard, this injunction application, basically, Millard, the suit, Millard, with utmost respect, Millard, to what my learned friend will say, is that this suit, as it stands, Millard, probably cannot proceed because of the fact that there is already somebody in the picture. And now, the thing is, and that I have brought it to it's not that during the pendency of the injunction application, it's on the day it is being heard, Millard, the court did not have. But Millard, the court did not decide on the issue just because Mr. Mitra did not have a copy of this register. Now we have annexed it to the affidavit in opposition. And Millard, they have also used a reply. So Millard, today, the question is only this, that whether he is entitled to an order of injunction, and that of course Millard, my learned friend will.
Yes, Mr. Mitru.
So
You start.
I'm
You start. এইটা ছোট করে একটা দাও না এর মধ্যে রাখো না
I have a copy. I'm not. So
No, I need A4 paper.
Kindly Millard, let him at least start.
Start. I'll.
Only thing is, Millard, I will start. Millard, they went to Supreme Court on 28th of February 2025, Millard. The Supreme Court was pleased to make an observation, Millard. Kindly look into the order.
Negotiating a mediated settlement or amicable settlement.
And the next page, my lord, I proceed on the basis that they are not, my lord, interested in the mediation. Well, kindly keep that on record because, my lord, in future, I do not want to, my lord, land into difficulty if they say that the plaintiff did not do it.
এইটাকে date wise রাখবে date 22nd February 28th February এটার নিচে এটাকে রাখবে এরপর রাখবে why Justice Krishna Rao's order?
Justice Rao released the matter, my lord.
No, that is in 24th February. Urgent matter possibly.
Oh, this bench was not sitting on that day.
Okay.
The interim order was till that date, so it was extended till that date, on that day.
Okay.
The matters were assigned before his lordship.
Urgent matter.
Yes.
Yes.
The dispute relates to a very large property, my lord, in the heart of the city, my lord, within the original jurisdiction at Lord Sinha Road. It's a huge property, my lord, 2 bighas and odd, nearly 3 bighas. Now, originally, this property belonged to, my lord, a company by the name of Basant Properties. It's a Birla company. Not very relevant. It's a Birla company. Now, my lord, in May, June 2022, my lord, one Ashok Lada, representing, my lord, that Basant Properties, my lord, approached the plaintiff before your lordship. And my lord started negotiations. My lord, the plaintiff, my lord, ultimately, my lord, decided to purchase the property and develop the same. My lord, if your lordship is pleased to look into my lord GA1,
GA1 টা কোথায়? Yes, got it.
let kindly come to page 2. I have given the description of the property in paragraph 2, page 2, my lord. Lordship got it. Description of the property and my lord.
4 lots in a road.
Yes. And my lord, who was the owner? Then my lord, kindly come to paragraph 3. I have spoken about this, my lord, Ashok Lada representing Basant Properties, my lord, approaching. Then paragraph 4, my lord, there were negotiations. The petitioner and Basant Properties Limited thereafter had entered into several rounds of negotiation when it was agreed that the petitioner would purchase the suit property. In such negotiation, the petitioner and the same Basant Properties were respectively represented by so and Mr. Ashok Lada. In this connection, copies of some WhatsApp messages are annexed. Page. Well, let kindly come to page 29. Or 28, ma'am. '29, kindly come. At the top, Lordship will find this is from my lord Ashok Lada. Or my lord, this is my phone. The WhatsApp messages exchanged with Ashok Lada. At the top, Lordship
64 crores is accepted.
65 crore of your property on Lorsina Road on as is where is basis is hereby accepted by Merlin Group. We will take time of 3 months to complete payment, in which we will also complete our searching and due diligence. Then, my lord, it goes on. Then, my lord, page 31. They say 99%, it may be 11 or 11:30, and AM will confirm by Wednesday, etc. It goes on. Then, my lord, kindly come back to the petition. My lord, paragraph 5. The petitioner being keen to purchase the suit property and to develop the same carried out due diligence in respect of the same in various government and municipal authorities. The petitioner caused an application dated 8th August 2022 to be made under the Right to Information Act 2005 to the Urban Landselling Department in respect of the said suit property, and response thereto dated such and such were also received by the petitioner. Copy of the application filed, etc. Searches were also caused to be made by the petitioner in the office of the Registrar of Assurance. The petitioner thereafter obtained an extract of the information book from the Kolkata Municipal. All these steps are taken. Then, my lord, kindly come to my lord, page 4, paragraph 7 is important. Here, my lord, the defendant enters this scene. Paragraph 7. While the negotiations between the petitioner and the said Basant Properties Limited were in progress, one Mr. Om Jalan, my lord, kindly take note of the name, my lord. It would be extremely important subsequently. I'll show your lordship why. Om Jalan, kindly keep in mind. And if your lordship, my lord, I will demonstrate why, my lord. One Mr. Om Jalan, who was known to the family of Mr. Shaket Mohta for the first several years, approached the said Mr. Mohta and represented Intrala as follows. A. The said Mr. Jalan and his family members were in management and control of different companies, including the respondent above named. B. The said Mr. Jalan and his family members, either by themselves or through the companies,
in their control had funds available with them for being profitably invested in the property. C. He would also like to develop such property through a reputed developer like the petitioner and would also utilize a part of such developed property as his own residence. So portion to be developed, portion to be used as his residence. Then paragraph 8. On such representation, Mr. Shaket Mohta informed the said Mr. Jalan that the petitioner was in the process of purchasing the suit property for the purpose of developing the same. On being so informed and knowing that the suit property is situated in a prime location in the city of Kolkata, Mr. Jalan expressed his intention to join hands with the petitioner for the purpose of acquiring and developing the suit property. On such intention and or interest being expressed by the said Mr. Jalan as aforesaid, and on the basis of further discussions which took place between the said Mr. Jalan and Mr. Shaket Mohta representing the petitioner, it was agreed by and between the petitioner, represented by Mr. Shaket Mohta, and the said Mr. Jalan that the petitioner will allow the said Mr. Jalan to purchase the suit property through a company owned and controlled by him on the condition that the said Mr. Jalan and such company owned and controlled by him who would purchase the suit property would get the same developed only through the petitioner. Accordingly, the petitioner represented by the said Mr. Shaket Mohta allowed the companies owned and controlled by the said Mr. Om Jalan to be party to the negotiations which took place thereafter with the said Basant Properties for purchasing the suit property. Now, let kindly pause here for a moment. Let kindly come to page 26 once.
Page 26.
Yes.
Affidavit.
The petition has been verified by the affidavit of Shaket Mohta. This is, my lord, according to me, is very important, my lord, because the initial negotiation or, my lord, agreement was between Mr. Shaket Mohta on behalf of, my lord, the plaintiff on the one hand, and Mr. Om Jalan, who was in control of or who is in control of, my lord, the defendant on the other. Shaket Mohta, my lord, has affirmed his affidavit, my lord, verifying this petition. I'll show before your lordship that Mr. Om Mohta, Jalan has never come forward. Because, my lord, the allegations are that Mr. Om Jalan approached. He said this. According to me, my lord, only he and he only could have, my lord, dealt with these statements. He has not dealt. I'll show your lordship the affidavit. Affidavit by completely, my lord, or somebody else, my lord.
This affidavit?
No. The affidavit in opposition. Now, my lord, kindly come back to page 5. Paragraph 11. Pursuant to the agreement as aforesaid, negotiations also took place between the companies of the said Mr. Om Jalan and the said Basant Properties Limited and of their respective advocates. Representative of the said Mr. Om Jalan and his companies, however, continued to keep informed the petitioner about the developments which took place from time to time. Such fact would be borne out from several correspondence exchanged by and between the petitioner and the respondent herein through email and WhatsApp messages. Now, these are, my lord, annexure I. My lord, kindly come to, my lord, page 41 onwards, my lord.
Draft conveyance.
Yes. Now, lordship will find that, my lord, it is being forwarded by, my lord, Mr. Muniz Junjunwala, who is, my lord, the person of Mr. my lord or, my lord, connected with the defendant. and to Shakit Multa. Now at the bottom kindly come forwarded message from Pulkit Chanda to so and so. Dear sir, apropos the meeting held today, please find attached the draft deed of conveyance for the captioned property for your perusal and observation. The draft has been aligned with today's discussion. Separately, we have also attached the draft of the newspaper publication that is proposed to be published, etc. Now, in this connection, my lord, kindly come to, along with this, my lord, kindly come to, my lord, page 74. My lord, WhatsApp messages exchanged with Muniz Jhunjhunwala. My lord, kindly come to, my lord, the message sent by him. Yesterday, there was a video conference call between our advocates, Basant Properties and Khaitan and Company being their lawyers. All points were discussed and they came to a mutual understanding. Our advocate sent the revised draft conveyance deed to Khaitan and Company and Basant Properties to approve along with draft of newspaper advertisement to be published. We are yet to get the approval from them. Basant Properties Kolkata head Mr. So-and-so has not gone to KMC to take a, that's not important. Now, it is being forwarded to me. Then kindly come to page 76.
So give me the gist of the application first. Then I'll look into the annexure.
Very well. My lord, the gist of the application is, my lord, as I have said, initially my client, my lord, decided to or negotiated to buy the property. Then
From Basant Properties.
From Basant Properties. Second step is, my lord, negotiation started. Third is, my lord, that Mr. Om Jalan approached my client and tried to, or my lord, said that they really want to invest money in a property and get it developed. Through some, my lord, reputed broker like Merlin, my lord, who is before your lordship as plaintiff, and my lord, a portion to be kept for his residence. Fourth is, my lord, that Merlin agreed to that. Agreed to that proposal. So, my lord, the next step is, my lord, that Basant Properties or, my lord, Mr. Om Jalan or the company of Mr. Om Jalan started negotiating with Basant Properties, keeping the plaintiff in loop, informing everything that these are the steps which are being taken.
So property was to be conveyed to Basant Properties to Om Jalan.
To the defendant, yes. Om Jalan, any company of
Any
Mr.
company
Jalan.
of-
Any company of Mr. Jalan here.
And development will be done by you.
Development would be done by.
But initial offer was, or initial negotiation was, it will be purchased by you.
Yes, absolutely. Absolutely. I, my lord, tried to accommodate Mr. Jalan when he said that he wants to, my lord, invest, basically. Now, my lord, nobody possibly, my lord, the Merlin is after all a developer. They would like to develop the property. So if somebody, my lord, wants to purchase and get it developed through Merlin, my lord, that's good for them. Now, that was, my lord, the next step that, my lord, the company of Mr. Jalan took steps, keeping, my lord, the plaintiff, the Merlin, my lord, in loop, informing everything. Then, my lord, a conveyance is executed by Basant Properties in favor of, my lord, the defendant. On the same day, a term sheet is executed between, my lord, the defendant and the plaintiff on the same day. One day, the conveyance and, my lord, term sheet on 11th of November 2022. Now, the term sheet, my lord, provided certain my lord, terms. Payments were to be made, steps were to be taken. Now, those were, my lord, and my lord, the development agreement, a formal development agreement was to be finalized. Now, I will show your lordship that documents on record to show that, my lord, everything was done. The draft development agreement was, my lord, exchanged between the parties, some suggestion from them, some suggestion from us. Ultimately, that was finalized. Then, my lord, Mr. Jalan was, my lord, requested to give a date, my lord, for execution. Terms of the development agreement, everything were finalized. And then at that stage, my client was to make certain payment. The payment was also made. No dispute. No dispute till that date. That was, my lord, the application was moved, my lord, on 1st of June. That was possibly, my lord, yes, 20th or 21st of May, 2023. Money was sent. Certainly, my lord, they, my lord, tried to get out of this agreement. By refund, they say that no, we are not interested, we refund the money. And, my lord, that is why the suit. When the suit was filed, my lord, on the first day, your lordship has seen, they came up.
Now they're trying to develop the property through someone else. And that's why the injunction was sought for. We'll hear you next day. কবে ডেট দিলাম ওটায়? Heard Mr. Mitro, the London Senior Counsel, in part, adjourned to 28th April for further hearing.
Lordship. Oh, my lord, the interim order is still.
Interim order is extended till date.
Eleven and 12.
এটা আমার না করিস না, আমার ব্রিফটা চলে যাবে তো ব্রিফ অফ
Item number 11 and 12.
I am appearing on behalf of the defendant. I am led by Mr. Rohit Mukherjee. My lord,
Which for the plaintiff?
Application.
One is demurrer application.
One is a demurrer, which is GA5.
Another is transfer to commercial division.
Another is transfer, which is GA4. Transfer is my application. On the last occasion, Lordship had indicated that Lordship will decide whether this is a commercial dispute or not.
Very possible this is a commercial dispute. Let it go to the commercial division.
I also wanted, it's covered by the definition of the commercial code.
Yes, let it go there and the demurrer application will be heard by this court. What is that commercial?
That GA4 is my application for transfer of the suit to the commercial division.
Who is the other side?
Rohit Mukherjee. I am
Rohit
led by
Mukherjee
Mr.
was there.
Rohit Mukherjee.
So come on the other day. Let Mr. Mukherjee be there.
Get an adjournment for 1 week, my lord.
22nd April. ঠিক আছে? Adjourn to 22nd April for hearing GA5, GA4 of 23. GA4 and 5 of 23.
Item 13.
Item 13. Sorry.
What is GA18?
Yes, in this matter, my lord, the defendant number 19 has died.
You are?
For defendant number 20.
But I'm appearing for defendant number 6.
Who is the plaintiff?
I tell you, my lord, this is my application. Every day, my lords, for some reason or the other, the matter is getting adjourned. If I tell your lordship the crux of the matter, my lord, everything.
Let me see what is GA18.
This is G18 for modification of an order.
How can the suit continue? Or the application continue?
Just a minute. Let me go into this. Modification of order 1st December.
Yes.
What is the order?
My lord, that order is annexed to the affidavit in reply by Mr.
Why it is not here? I will hear you, Mr. Lahiri.
My lord,
Let me understand the case first.
kindly take the supplementary affidavit, page 109. The last annexion. This is the order passed by your lordship on the 1st of December 2023.
Which page?
Page 109. The order starts from 110, 110. Well, the initial paragraphs are really giving directions. Well, the penultimate paragraph, the parties shall maintain status quo as to the possession, nature, and character of the suit premises in the meantime. Now, this application has been made, my lord, because we say that two of the properties which are sought to be brought into the till of the suit, my lord, saying that they are part of the joint family properties, should be outside the scope of injunction for the reasons we've stated in the petition. But actually, there are two groups, the Sharmas and the Guptas. There were disputes between them. The disputes went to arbitration. An award was passed. The award was challenged, and the challenge went right up to the Supreme Court. The award was affirmed. Thereafter, my lord, the parties, my lord, the Sharmas filed a suit for partition. Now, in terms of the award. Now, in the suit, my lord, there are two properties, one at Aryanagar in Kanpur and another in Baswandi, Kanpur, which we say, my lord, should not remain within the scope and ambit of the injunction for the simple reason, my lord, that these two properties are initially at a, well, may I take them one by one?
9/1 Aryanagar.
9/1 Aryanagar.
Purchased and acquired jointly by 4 of the original defendants. 5, 6, 7, 8.
What happened was there were sales tax dues. The sales tax authorities, my lord, attached the property. It was put up by way of auction sale. My clients, my lord, purchased the property, my lord, in that auction sale. Now, the auction sale was never challenged. The auction sale has been referred to in the plaint. They have admitted the fact that the shares and the property has been sold and purchased. So, my lord, we say we have certain documents also to support that sales certificate. So this goes outside the scope and ambit of the joint family till or, my lord, the award, because this property, my lord, was purchased by these defendants who have made this application, my lord.
This is not part of the family hodgepodge.
This is not part of the family hodgepodge. My lord, I wants to hear that. I should show your lordship the pleadings, my lord, later on. My lord, so far as the second application is, second property is concerned, it is a wholly owned property, my lord, of the defendant number 7, which vested on his heirs.
Dalalpura Bans Mandir, Kanpur.
Yes. That, my lord, is a wholly owned private property of the defendant number 7, which vested on him. And, my lord, so that also
which became vested on defendant number 7, ABC on demise.
On demise. There was a will. The will was probated. And, my lord, the mutation certificate was given.
Both these are suit properties.
Yes. Therefore, we say that they should not be suit properties now. They should go outside.
Presently, these are suit properties.
Presently, they are. And my lord, the second one is not in the award, but this application has been made
Instant
by us.
suit is filed.
Yes.
Certain properties are there which are called suit properties.
Yes.
These are suit properties as of now.
Well, not all of them. Well, the first
let him submit. What you are saying? Is it suit properties? These are suit properties or not?
Yeah, just clarify. Because the first property, 9/1 Aryanagar, though formed a part of the award initially, but Mulod's was subsequently attached by the sales tax authorities for non-payment of their dues. Now, Mulod's pursuant to attachment, this property was put on public auction, and Mulod's by a sales certificate dated 1st June 1985, Mulod's, the property was purchased by the 4 defendants. Now, Mulod's, your lordship.
Let me see the suit.
Mulod's, your lordship.
Let me see the plaint.
It's there.
Mulod's, in the plaint, paragraph 25, they have admitted that it has been sold. Mulod's, kindly take the plaint. I have filed the plaint in the supplementary affidavit. My lords, we kindly take the supplementary.
Sir, I'm not supposed to hear this application.
This is for modification of your lordship's order.
So,
So,
in terms of the notification.
in terms of the notification, my lord, the other applications have been released by your lordship. But since this concerns, my lord, modification of an order passed by your lordship, that is why
So
we
let the
say-
plaint come.
the plaint I have annexed by way of a supplementary affidavit. Kindly come to page 27
of the supplement.
of the supplementary affidavit,
Para 25.
para 25 of the plaint. My lord has got it, my lord.
Where are the suit properties? Description of the suit properties?
Copy of the schedule of immovable properties allotted to the Sharma Group. Copy of the schedule of
Page
the party.
43.
Kindly see, my lord, page 43.
44. Come to page 44.
Yes, item 23. Aryanagar property is here, but the other one, my lord, the
89 by 279 Basmandi.
Basmandi property, my lord, is not there. So, in my humble and respectful submission, if one property went outside the scope until of the joint family properties by reason of the attachment by the sales tax authorities, and
No, so I understand. So far as the other property that is in Kanpur,
Both are in Kanpur.
Both are in Kanpur.
Dalilpura is concerned,
Yeah,
that is not included in the schedule.
not included.
So this injunction application or this injunction order should not affect that one.
In the company.
Well, they say that this particular property was purchased by a company.
And that is in
And that is in the schedule. But that is not so because my lord,
Where is the order?
My lord's order I just placed, it's the last
100.
annexure in the supplementary affidavit.
Of the suit properties. This is not a suit property. Why this will be affected?
But the company, my lord, they claim that this particular suit property belongs to a company. That company, my lord, is part of the award.
Oil India Corporation.
I mentioned that the injunction.
If my lord makes it clear that this property is not included in the suit properties,
Yes.
my lord, that will be fine.
Why should it be clarified? And so far as the other property is concerned, I cannot adjust that this is a suit property, this should not be affected or not. This is list. Either you amend it, once it get amended, it will not be in suit property.
With the deepest of respect, my lord, I don't think I've been able to make myself clear. There are two properties. The first property, my lord, is included in the suit properties.
Other is not.
The other is not.
So either you submit or him, let him submit. This is very disturbing.
Well, then let him submit. I realize. Well, there are two properties. The first property is part of the suit property. Now, I say that no longer remains in the till of the suit property. For this reason, the sales tax authorities has attached that property, my lord, because they had certain claims against the Sharma. There was an open auction. In the open auction, I bid and I purchased that property, my lord, out of my own funds.
That is subsequent to institution of the suit.
Prior.
Much prior.
Yes, prior to, so far as this property is concerned, you are the owner, I understand.
Yeah.
You are not you, this is different number 4 to 8. 4, sorry, 5, 6, 7, 8. 5 to 8.
We are for them.
We are for them. This application is made by them.
7 and 8.
So, first of all, my lord, let us take one property at a time. If my lord is satisfied that once an auction sale has been made by a statutory body.
No, one first thing is, let it be clarified, the other property That is not included in the suit. I have mentioned in the order only suit properties, injunction in respect of the suit property, so the other properties will not be affected. Because order, injunction order or status quo order is in respect of the suit properties only.
Well, that might, unless my lord clarifies that because
All right, let there be clarified, but that is not in suit properties.
it is not included in the list of suit properties, but they are trying to bring it into the hotspot of the suit properties by saying that it originally belonged to a particular company.
I am now, sir, I am now right now concerned with only modification of my order.
Yes. Yes.
This much. So one thing is that will not, I am clarifying.
Very well.
So far as the other is concerned, I will have to hear the other side.
Yes, my lord will definitely hear that. But the point is that is sold and they have admitted the sale in the plate.
All right, I got your point. Next year I will hear you.
Yes.
Milord, may I only submit? I'm appearing for defendant number 6. In
Come on the
matter.
next date.
I'm very deeply obliged. Deeply obliged.
I will kindly record that the defendant number 19 has died.
No, sorry, I won't do this. Because I'm not a regular court. I'm only hearing this application for this purpose, for modification of my order.
We'll make a submission on the next day, Milord.
I'm appearing for the respondent.
Heard,
My lord will
Mr. Bose, Learned Senior Counsel, in part, adjourned to May, first week of May or second week of May.
My lord, as soon as your lordship's list.
So other dates are congested because I am
leave it to my lord. I leave it to my lord because this has to be heard by your lordship only.
6th. 6th is okay?
Yes.
Yes, Milord.
But only one thing, I'm appearing for respondent number 5. I'm supporting the contention with regard to property 9/1 Arya Nagar, my lord, because that has been sold by way of auction. That
Come on the next day.
Yes, because
Very grateful.
I'm deeply obliged, Milord.
Item 14.
Well, item 14, Milords, may I please? Milords, my application seeking probate of last will and testament of Sri Kumar Daga, Milords. I appear on
Citations are issued.
citations issued,
Bring
Milords.
your witness.
Milords, my witness is was here, Milords. Today, Milords, your lordships want me to prove the will in solemn form, Milords.
Yes.
Milords,
Will
the
be fixed for witness
yes,
action.
yes.
Bring your witness. देखिए report टा किया है caveated.
And Milords, one caveat, 2 caveats are filed, discharge, Milords, orders recorded. Milords, may I just indicate the orders?
Where
to
is
your
that order?
Milords, kindly. Milords, first is 2nd May 2024. 22nd May, Milords. 22nd May, the first caveat was discharged, Milords. GA2.
Plaintiff witness was to be examined in chief.
Yes, Milords. And Milords, if your lordships will kindly take 22nd May, order, the caveats have been discharged. 2024, Milords. 4 December. Milords, the second.
The application will be fixed. The proceeding will be fixed for witness action
Yes.
on 13th May.
Deeply obliged.
Item 15.
Milord, if I may, Milord, indicate consent of all, Milord, heirs in intestacy, probate ought to have been granted. But an application was made for Milord leave to Milord put in caveat and file.
I only asked one question and I'm looking for clarification.
Yes, Milord, if your lordship recalls.
Not from you, but from Mr. Bachua.
Yes. And Milord, now what is happening is, now the other properties concerned, we want to deal with all the beneficiaries together, want to deal with them. But we can't do that because this is, Milord, pending. I am, Milord, honestly, Milord, expressing the real concern of my clients.
Maybe, but let this application be disposed of
Now,
first.
Milord, either he gives it, Milord, he's taken a few adjournments, Milord. I'm requesting them to, Milord, conclude the hearing. With Mr. Bachawat there, I'll never say that, close it or something,
Yes.
but I'm requesting you.
Bachawat was supposed to do the argument today. Yeah, he's on legs, mother. He's requested me
Fixes the date, Mala, in case he can't make it, I'll.
Yes, I request you. I'm not.
21st April?
21st, please. Go ahead. Commissioner, 21st. I'll also request Mr. Bachao. The point of law, my lord wants clarification. It's better that he comes.
This is the only thing.
Yes, yes.
On request, my lord, in the preceding Thursday, my lord, if your lordship keeps it. After
Very well.
21st.
Very well.
That is 24th April.
24th.
24. 21st, my lord, is Monday.
Yes.
Lordship generally takes up these matters on Thursday.
No, there is no such thing.
Very, very good.
21st is Monday. 24th, you are saying. Monday, have you any problem with Monday?
But I'm told Mr. Bachavat may not be
Very.
in the only the otherwise I'm there. My lord.
24th April then.
If he's stuck up, my lord, I'll
Yes.
24th April.
In fact, your lordship found that paragraph from the Birla judgment that if you are claiming adverse to the will, you
have no caveatable interest.
You have no caveatable interest.
And that part is not in challenge.
wasn't-
That part, there
Yes,
is no
it's not-
dispute regarding that part. What is caveatable interest? There is dispute regarding this.
No, but there, my lord, if your lordship recalls, I had cited those judgments that on the definition of caveatable interest as per
No,
Mr.
I'm not speaking of caveatable interest. One part is positive interest.
Yes.
What is there? If whether slightest or bigger,
Yes.
that is one thing.
Yes.
And what is not? Where there is no caveatable interest, that part is there is no dispute on that part.
No, there is no dispute on that part. And even, my lord, what they
Whether
say
the legal
doesn't-
heirs and successors will come, or the person having slighted Mr. Bachwat is there after fixing a date.
my lord, that slightest interest is where, my lord, the divergence
Slightest delay.
Slightest delay.
It seems that I was deserving of something. That when the date is being fixed, I made an entry.
Right.
His argument on slightest interest is contrary to the Supreme Court judgment, which has
No,
been referred to larger bench.
this point is that larger bench is that which is slightest interest, which is bigger interest. So to resolve the conflicting judgments.
Yes.
But there is no conflict on the point what is not caveatable interest. There is no dispute on that point, on that aspect.
Has to be real interest. That's the
If someone raises an interest which is adverse to the or destructive to the caveat to the testator's interest, then he has no caveatable interest. That part, there is no dispute on that part. 24th is okay.
Item 16.
Milord, 16, Milord, I appear for the petitioner, Milord. Milord, my notes are ready. I had already filed a note previously pursuant to your
Witness
lordship.
action is complete.
No, this is for revocation of grant of probate.
Oh,
Milord, my supplementary notes are also ready. Milord, may I file it? Oh, you have also given copies, Milord.
let me see the application, revocation application first.
My learned friend has relied on some judgments. These were not placed.
Oh, that one. Yes, I can remember now. Signatures differ.
Yes.
Yes, my point were how forgery and fraud can be placed together.
Yes. Milord, that we have covered in the supplementary note.
Have you got it?
Yes, Milord, I got it.
What would be your response?
Where have you said? Milord, only paragraph 5. He has made a submission. That is all. The Lordship will see page 3, paragraph.
Mutually destructive, please.
Yes. That was my your Lordship's point, my lord, which, my lord, we had developed. This
is yours, supplementary written notes.
This is filed by them, my lord. Supplementary written notes of argument filed by the applicant. Paragraph 5. Their answer is how they answer that question, my lord. The argument is untenable and baseless. The applicant is entitled to order of revocation of grant of probate as the same was obtained fraudulently by perpetrating fraud. Fraud has been perpetrated by the executrix by making false suggestion and by concealing material facts and circumstances of the present case. The executrix has falsely suggested that the applicant affirmed an affidavit. Go answer to forgery and...
No, Lordship sees, Milord, page 4 of my note, Milord. Because Mr. Mukherjee has relied on the Steel Authority of India judgment which is reported at 2006-12 SCC 233. Kindly see the the last paragraph of page 4 of my note, the supplementary note. Kindly see, in the present case, by falsely suggesting that a consent affidavit was prepared and by falsely suggesting that a declaration and further affidavit were prepared by the applicant, the executrix has perpetrated fraud before this court. Now, my lord, kindly see, mutually destructive.
Forgery constitutes fraud.
Yes. Now, kindly see the judgment 1996 5 SCC 550. My lord, I have annexed that judgment to my note.
Mr. Mukherjee, go through it. Let me go through it also. Come on the next set.
Yes, my lord. My lord, I think, my lord,
which paragraph you are referring to?
Yes, my lord, we have second because my lord, we have given them the copy of my note on 17th of March.
No, you
Yes,
refer
my
to
lord,
the paragraph. Refer to the paragraph.
Yes, my lord, kindly see, we have indicated, my lord, page 5, 1996 5 SCC 550, paragraphs 26 to 30, page 5 of my note.
Just a minute. Let me come one by one.
If lordship takes
Still
page
authority.
5 of my note.
So far as Indian Bank is concerned,
Yes.
paragraph 26 to 30.
Yes. My lordship will find from page 20 onwards.
Actually, 24 onwards. Paragraph
Yes.
24 onwards.
Yes. But kindly see para 27.
Yes, let me go through it.
Yes.
Fraud is innocent.
Right, these things are there.
Yes, not only, I would
but
like to.
When you are alleging fraud is integrated element of forgery. There is fraud.
Yes.
But what is the allegation is that this affidavit was signed by someone else.
It is my signature does not appear in that document. It was prepared by someone else before the notary public and used in the probate proceeding. Well, that is number one. Now, if lordship sees the other documents that has been disclosed in the affidavit in opposition, the signature which is there in the affidavit used to obtain probate, that signature does not match with the signature disclosed in the documents in the affidavit in opposition. If a document is forged and if one specimen signature is used, that specimen signature will be used in other documents also.
Have you filed any application for handwriting experts?
No.
Evidence?
But on the face of it, lordship will see that there are enormous discrepancies. On the face of it, if I show lordship few documents, kindly sticks my application.
No, you have shown that. Now you are in the argument stage.
Yes.
Point of law.
Yes, in fact, we had concluded also, what fell from your lordship is whether forgery can be fraud or not. Now, lordship sees page 25
Yes,
of
I've
my
seen
note.
that.
Page 21 once, para 28. Page 21 of my supplementary note.
No, you please.
And in the affidavit in opposition, it is their admitted case that I was not there in India when the affidavit was prepared.
That you said it's a manufacturing consent.
Yes. Paragraph 28 of the 19.
So there was forgery.
Yes, kindly see page 21 once of my note.
Page?
Kindly see
supplementary.
My note. Yes. Kindly see page 21 once. One paragraph I would like to show. Yes, this is 1996 5 SCC. Kindly see para 28. From the above, it would be essential that
fraud is
an
essential ingredient
of forgery. So when one forges my signature, the person perpetrates fraud. Fraud is a bigger genus. Forgery is a part of it. Every And we have also disclosed a recent judgment, not so, 2022 SCC Online Supreme Court page 1550. My Lordship sees paragraph 30, which Lordship will find at page 43 onwards. One of my notes, supplementary note, page 43. Kindly see towards the bottom, paragraph 30, in P. Ramanatha Iyer's Advanced Law Lexicon, Volume 2, 5th edition, 2017, the entry relating to the word fake simply directs the reader to the entry relating to the word forgery. Therefore, one has to go to the entry relating to the word forgery to understand the meaning of the word fake. The entry relating to the word forgery is quite long, and it begins with a reference first to section 463 of the Indian Penal Code 1860, which defines forgery. The normal forgery has been defined. Now, kindly see, yes, kindly see page 44. While it is true that there is a distinction between fraud and forgery contains some elements that are not included in fraud, forgeries are a species of fraud. In essence, the crime of forgery involves the making, altering, or completing an instrument by someone other than the ostensible maker or drawer or an agent of the ostensible maker or drawer. And kindly see,
yes, I have seen this.
Yes. Kindly see the last paragraph at page 44, Malad. Forgery constitutes fraud and no legal title passes to the transferee.
That is at the end.
Yes, towards the end. This is 2022 Supreme Court. So when one forges a document, the person concerned itself acts or perpetrates fraud. That is the reason why my first argument before your lordship was that the probate was obtained fraudulently because a false suggestion was made at the time of obtaining the grant. The false suggestion was, I was present when the affidavit was affirmed. That was the false suggestion that was made.
All right.
But these are my humble submissions, my lord.
You reply if any.
But I have some reply after that. My lord will kindly see what is the fraud, which first. And also, my lord, before, since your lordship is here, kindly see, my lord, page 21, paragraph 30 also. His note. My lord, the judgment of 96 Supreme Court, paragraph 30. My lord, the judgment which my learned friend cited, my lord, 1996 5 SCC, his supplementary note, Indian
paragraph
Bank versus
30.
Satyam, paragraph 30.
Forgery and fraud
Are essentially matters of evidence which could be proved as a matter of fact by direct evidence or by inferences drawn from proved facts. Well, it is extremely important here because evidence comes into matter of fact. Evidence is something which is important. In fact, I have not filed an application, but I have judgments, my lord, in an issue where a person is disputing that it is his signature or someone else's signature in a case of revocation. And where I am claiming here, man, it was the person who has signed it. It was her signature only. And today she's being coerced by someone else that are outsiders.
These are extraneous elements.
Extraneous elements. So to show that there is actually no forgery, there is no fraud at all. In fact, what is happening today, the application for revocation itself is a matter of fraud. And that can be proved only by way of evidence to see whether the signature was in fact hers or not. That has to be taken into account. And the best way to do that is by bringing that lady herself. Nothing else is required. This lady, she has signed, she has now claimed to have filed this revocation application, and it is her signature which is appearing in the affidavit and also in a consent form which is there. There are two documents. One, the day after a few days after the death of the deponent, the will was read out. All the family members were there. All of them signed signed a particular document. That is 2 days after the death, saying that we will a probate application will be filed and we will consent to the will being probated. Subsequently, she also filed an affidavit. It is their claim.
When the probate was granted?
One.
On 15th of March 2019.
15th of March?
15th of March 2019.
My lord, we'll keep a few dates here in mind, my lord. 15th March.
So it is in time.
My lord, will is of 29th March 2017. It's a registered will. Your lordship will see 1st April 2018, page 26 of my affidavit. My affidavit to his revocation application.
AO.
AO.
Yes.
Your lordship will find, my lord, this is a few days, sometime after the death. We, the persons named herein below, being the legal heirs of Shamsundar Lohia, the deceased above named, do hereby declare that we have no objection whatsoever to the grant of probate in the goods of the said deceased in favor of the petitioner above named by this honorable court, and we hereby accord our consent for the same. There are five people named. The first person is the lady concerned here. My lord, if your lordship also sees the genealogical table, which is, my lord, annexed to the petition, page 10 of the petition, who she is.
Yes, I've heard these points. Come on the next day, let me go through it.
My notes are also there. My principal submission, my lord, is that this lady, she herself has signed this declaration and also the affidavit of consent. Today, my lord, out of pressure from her in-laws, which I have established also, well, there was excellent relationship much after the death of this deceased, also much after filing of the probate application between the executrix and this lady also, this applicant also. Subsequently, this applicant had been beaten up by her own husband. There is a complaint which was she had filed in Australia. There is a police record also to that effect, which I have annexed. Subsequently, it is that husband who has pressurized her to file this application. This is also proved by way of the fact, if your lordship sees the affidavit in reply, it has been affirmed by the father-in-law.
The petition was affirmed by the petitioner.
All right.
Let the lady come in.
I had demonstrated to
All
your
right. Should
lordship.
I reserve it?
Find my judgment.
Should I reserve it?
No, my lord, I want
Yes,
to
lordship
come
will
in.
kindly
Your
reserve
lordship
it.
will read the facts, my lord. Read the notes which are
I
there
have gone
and
through
fix
it.
one more time. So that, my lord, if there is any doubt, I will show. My principal point right now is, my lord, if this lady is brought before your lordship, everything will become clear. There is no pressure on her. The lady comes herself, and this is provided.
That is up to them whether they will bring.
The lordship has that. Since they are seeking.
No, I can show, my lord, from undisputed facts that there are discrepancies in signature.
For trial on evidence.
But that is not required.
Adjourned to 30th April.
In similar cases, I've cited judgments for that, my lord. In similar cases, court has called for trial on evidence where the person has been.
My lordship will kindly reserve because, my lord, I'll show you the only question that fell from your lordship is whether forgery is fraud or not. My lord, that I have corroborated by those two judgments. And my lord, lordship will, my lord, see, my lord, the notes, my lord, we have given page numbers.
My lord, if your lordship has any doubts for that.
30th
Yes,
April.
my lordship
That
will
day I will
reserve
reserve.
it.
Pretty sure argument on that date.
Yes, 30th April. Your lordship will see in my notes, my lord, the trial on evidence, the judgment which I have relied
Yes,
on.
and that I have distinguished in my supplementary note.
Distinguishing is obviously possible, but that's a different matter.
আজকে 10 তো that day I will reserve for judgment.
Yes.
Item 17.
Lord, I appear on behalf of the petitioner. My lord, point is very short, my lord, in this matter. Affidavits have been exchanged. My lord, may I tell your lordship why, my lord?
Who is the other side?
My other side is Mr. Chaudhuri and Mr. Mitro is also. Now, my lord, point is very short, my lord. Before lordship looks into the document, I tell your lordship what had happened and what compelled me to
What
come
is
today.
GA5?
That is, my lord, the application which has been filed, seeking certain direction on the receiver to comply with the order of this honorable court. I tell your lordship, my lord, what had happened. A gentleman called, my lord, Mr. Arun Kumar Bhutoria, he passed away in 2011. During his lifetime, he flourished, my lord, earned a lot of money. He was a very successful businessman. All on a sudden, he passed away. Thereafter, since there was no will, my lord, an application seeking letters of administration was filed by his two sons. And there, my lord, after special citation was issued, my lord, wife of Mr. Bhutoria, my lord, one of my client, my lord, he, my lord, lodged a caveat and filed an affidavit in support of the caveat. Presently, my lord, there are 4 legal heirs, 2 sons who are the applicant filing an application for letters of administration, caveator, my mother, our mother, and another lady, my grandmother. So they are the four shareholders, 1/4 each. Now, what had happened, my lord, at the time when the application for letters of administration was filed, Lordship knows, my lord, an affidavit of asset was required to be filed, because based on that, letters of administration will be granted, my lord, to do the needful. Now, my lord, I appear on behalf of one of the applicants, the eldest son. Application for letters of administration was filed jointly. Subsequently, my lord, I realized, my lord, after my mother, my lord, pursuant to her affidavit, pursuant to lodging the caveat, filed the affidavit, that some assets were left out. So all are to be included in the affidavit of assets. Only then, my lord, grant will become complete, my lord. After realizing that, my lord, I supported my mother's stand. Now, my lord, since there are huge properties involved, hotels, other companies, all from the fund, my lord, which was generated by my late father, my lord, an order of injunction was passed when it was moved before the trial court, restraining the parties, my lord, to transfer or to alienate the properties in the nature of status quo. Receivers were appointed. Both party advocates were appointed receiver to do the needful, to collect rent, and to ensure that the properties of the deceased is protected. However, since both parties advocates were appointed, my lord, they were not ad idem on certain issues. Then an application came. Application was filed before the single judge, saying that parties advocates are not ad idem. Please appoint a third party. A third party advocate was appointed, discharging the first two advocates. Now, my lord, that particular gentleman, my lord, held meeting, but since there are huge properties, my lord, he could not handle it. And my lord, there was an objection also came from my brother's side, who is another applicant. That, my lord, compelled me to file an application challenging the order whereby a single receiver was appointed, discharging the party advocates who were initially appointed as receivers. Appeal court said, considering the vastness of the properties, we are appointing 3 receivers, and directed the receivers to ensure that all the properties of the deceased is protected. Now, the difficulty is after that, my lord, joint receivers, my lord, 3 receivers held meetings. Specific objection came from my brother, who is one of the co-applicant, the letters of administration filed by me and my brother, relating to certain properties. My mother said some of the properties were left out. She had given a particular of the properties. I supported. I said, very well, let the inspection be made with regard to all properties mentioned by my mother, because some properties are admittedly left out, to which my brother objected. And that's why the receivers held that since the parties are ad idem, we cannot preserve or do the needful relating to maintaining the property. And the allegation is, my lord, the money is being siphoned off at the instance of my uncle, at whose dictate, my lord, my brother is, my lord, working. And other allegations are there, my lord, changing the name of the directors. There are several companies. Under this background, my lord, this application has been filed for a direction on the receiver to just make an inventory so that all the facts come before your lordship. Now, my lord, kindly sees 2 orders. I will not trouble your lordship more than 5 minutes. Kindly, my lord, comes to the order of the division bench, because that's really when my cause of action commenced. The order of Justice I.V. Mukherjee, who was the presiding judge then, page 192.
Second volume?
Yes, absolutely. Page 192 একবার জজ সাহেবকে দেবেন। Lordship has got it, Miller.
You refer to this.
Yes. Kindly, my lord, turns over to page 193, the last paragraph, which is the operative portion. May I, my lord, place it? We are of the opinion that considering the size and value of the estate, for its proper and transparent administration to avoid dissension and dissatisfaction amongst the parties, and for smooth distribution of the assets of the deceased, more than 1 receiver is necessary. Instead of 2 receivers, it would be better if there were 3 receivers to act jointly or by majority. We are not removing Mr. Somrat Mukherjee, who was initially appointed as a submitted millet after the party advocates were discharged by the coordinate bench, and that order was challenged. We are not removing Mr. Mukherjee. In addition to Mr. Mukherjee, we appoint Mr. So-and-so and Mr. So-and-so as joint receivers. They shall periodically hold meetings, take decisions, prepare meetings, and circulate the same amongst the parties. They shall file reports in the court every quarter of the year. Then, my lord, each of the joint receivers shall be entitled to the remuneration. I am not on that. Now, but unfortunately, my lord, because of the objection, my lord, raised by my brother, my lord, they can't do it. And that will be evident, my lord, from the minutes. Kindly, my lord, takes up the minutes. Now, page 237, now, my lord, lordship kindly sees. Because one of the points in their affidavit they had taken, there is a delay. Page 237, lordship would find. This is really when my cause of action commenced. Lordship would find all parties were present, 3 receivers were present. Discussions were made, and the finding of the receivers, lordship would find, that compelled me to come before this honorable court by filing this application, is, my lord, towards the bottom penultimate paragraph, my lord. Lordship, my lord, may I, my lord, place
I've
it?
seen this. Parties, if the parties
Yes.
are
There appeared to be a big confusion as to the immovable assets of the deceased. If the parties are addendum to the immovable assets of the, we can surely look into the details as to the devolution of the ownership inheritance of the properties. This is really my grievance. Now, my lord, what I am asking.
So let there be a complete list according to you.
Absolutely. Kindly, my lord, consider what I am praying before your lordship right now. Whether it will be cause any prejudice to anybody, that's lordship, my lord, kindly sees. Kindly takes up my application, page 15. For the time being, what I am praying, A, an order be passed directing the joint receivers to make a complete inventory and collect information about the status of the companies mentioned in the list being annexure K to this application, that annexure lordship would find at 241. And what is their point, my lord? I must tell your lordship. One is the limitation, which probably does not stand. Cause of action commenced after the receiver has recorded this. They say, my lord, their point is already there. I'm sorry, my lord.
Yes.
They say already an application for letters of administration has been filed. Good, bad, indifferent, affidavit of assets have been filed by the 2 sons. I'm one of them. Why there should be any departure to that? Only inventory should be made in respect of that. To my respectful submission is no. My lord, the entire estate, what are the properties that belong to the estate, that has to come. Today, it's about granting letters of administration to a party. If a property is missed out, and if my mother, who is also a co-sharer, she will also get 1/4, files an affidavit saying these are the properties that have been left out. Did
you file any caveat?
I didn't. I filed the application for letters of administration along with my brother. I gave particulars of some of the properties. And I admit today, though I gave particulars of some of the properties, few properties have been missed out, left out. And my mother had given full and complete picture.
Your brother, your son.
Arun Bhutoria is the man.
Yes, your son.
I'm the eldest son. Eldest and youngest both filed the application. Citation issued. My mother appeared, lodged caveat, filed an affidavit in support of the caveat. Nobody is objecting to the grant. My mother is saying, no, you have given particulars of 20 properties and 20 companies. Actually, it should be 25 properties and 25 companies. This is the only difference. My grandmother is another co-sharer. She did not have anything to say. She had given consent. Now, my lord, the thing is, today, if one party says no, 30 properties should be included in the estate, and the other says 25, what will the court do? Court will has to decide this issue after trial, certainly. Now, for the time being, prima facie, at this stage, without going into the detail or deciding the title, court passes an order directing the receiver to make an inventory in respect of the assets and properties mentioned in annexure K. Who will be prejudiced? That's the point. Lordship is not deciding the matter on supposing inventory comes in respect of 30 properties. If finally it is found, no, 20 properties belong to the estate, 10 will be discarded.
So basically amendment of affidavit of asset.
Absolutely. Amendment of affidavit assets, they're not agreeing, but what I'm
If
saying.
it is amendable. If
Yes.
it demands amendment.
Yes. Now, question is, supposing court may think or they may say, no, what you are saying is not correct. At this stage, on an interlocutory application, what the court will see? Preservation and proper administration of the estate. If finally court finds no, one property did not belong to my father, obviously that will go. But for the time being an inventory image, nobody will be prejudiced. And kindly see one provision of the Indian Succession Act, just one provision. I'm not relying on any judgment. Because caveator is also, caveator also has a right. It's not that she's a completely outsider or an imposter. She is also entitled to claim wife. My mother. Kindly have a look at section 273 of the Indian Succession Act. Conclusiveness of probate or letters of administration. Lordship has got it, Millard. Why this application? Why, my lord, proper administration and preservation is necessary? Probate or letters of administration shall have effect over all the property and estate, movable or immovable, of the deceased throughout the state in which the same is or are granted, and shall be conclusive as to the representative title of all the debtors of the deceased and all the persons holding the property. Absolutely. So what's wrong or what prejudice is because even order in terms of prayer is granted? So
All right, I got your point.
For the
Hardik,
timing,
next year I will hear you both.
The widow, Varun Bhutoria.
May I file my
My son, one of my sons, will make an application that the
What is this?
reply, my lord, to the affidavit filed by
You reply.
my lord, my brother, who is a co-applicant in the letters of administration.
This is the affidavit in reply to affidavit of Rajat Bhutoria.
Yes, my
Rajit
brother.
Bhutoria.
Rajat Bhutoria is opposing. It is otherwise, my lord, apparent.
You are the petitioner.
I am the petitioner. I am the petitioner. Lordship would, my lord, kindly, my lord, realize one thing, my lord. Application filed jointly by me and my brother. I have made a departure.
Affidavit in reply filed on behalf of the petitioner be kept in record. Heard Mr. Deb in part. Mr. Deb, for further hearing, fixed.
But kindly do it at the earliest because some protection is necessary, and that is evident from the receiver's report, my lord, that nothing is happening.
I am for the widow of Varun Bhutoria. My husband died suddenly. And who are the beneficiary? The two sons, my two sons, myself, and his mother.
Your mother-in-law.
Very sad, my lord, when the mother is alive and the son dies. But anyway, it happens. So now what is being, I filed a caveat. I filed an affidavit in support of the caveat. That is now been treated as a written statement. PLA has now become a testamentary suit. Now the question which remains is, one of the sons today finds that the assets which he had filed initially, PLA, do not cover the complete estate. And there may be other assets because at that time he was quite young and he was being, the affidavit was not according to his uncle to the Arun Bhutoria's younger brother, Anil Bhutoria. He said, this is the affidavit, you sign. Right. Widowed, I was the widow. I knew my husband's assets were more than what was declared in the affidavit of assets. So I filed a caveat and in my affidavit I disclosed the total assets, which were not disclosed in the PLA. Now, my lord, one of the sons, he has realized that his uncle, his father's younger brother, who had brought him into the business, was playing dirty. And he had, under the influence of the uncle, not disclosed the entire assets of his father. Now, if the assets are more, what happens? Each one stands to benefit. The cake is bigger into the slice.
Slices will be bigger.
So we cannot oppose for the sake of opposition. I can, if I want to oppose, I can take 10 different ways.
So according to you, this application may be allowed.
Maybe I am for the widow. Because, you know, if the cake is increased in the trial, if it's not,
Everyone will be benefited.
everyone will benefit. No one is.
And in fact, if the inventory is prepared and placed before the court, you will check it. If you think it is objectionable, you will raise objection.
At the trial, testamentary suit, you can.
Yes, Ms. Chaudhary.
Your lordship is hearing this every day. This is not part of the assets of the testator. Yes, that is done. May I file my affidavit?
ওটা কেটে দিন, ফ্রেশ করে করুন। এফিডেভিট রিপ্লাই ফাইল বাই মিস্টার দেব on behalf of the petitioner be kept in record. এটা কি দিচ্ছেন?
Affidavit in opposition by the
Affidavit in opposition filed on behalf of the widow, namely the defendant, be also kept in record.
But I kindly record that I will not file and reply because she has supported my milord.
There is another affidavit filed by your affidavit in opposition filed on behalf of
Brother,
no
my brother.
younger son or elder son,
younger son.
Younger son by Mr. Chaudhary be also kept in record. Heard the application in part.
I have heard one thing that the affidavit which is filed by the defendant is not served upon him. So it should
No, please serve it.
should be expunged. Unless they serve it, it should be expunged.
Yes. Copies of affidavit shall be served on the adversaries if not served. Fix 8 May for further hearing.
Milord, only one thing, milord. As I submitted, generally I don't make request. Considering the urgency and the receivers.
I have so many matters, Mr. Dev, you know it.
I leave it. I will not say anything. I leave it.
Lord, I am the appealing for the widow. If one of my sons wants this father's estate to be inventarized, how can I prevent them? It will inure to the benefit of all the benefits.
Let me hear Mr. Chaudhary on the day. I got your point.
I have nothing more to say. And the affidavits are only because it annexes a lot of documents. It will issue, the affidavit is only 9-10 pages. It annexes all the documents so that later on it cannot be said this document is not there, that document is not there. For the supplementary affidavit.
So bringing all the documents on record.
Kindly give me deal with this affidavit which is served upon me.
But it's my application.
Supplementary affidavit.
Yes, and file an affidavit in opposition to the affidavit.
Supplement liberty is given to Mr. Chaudhary to file supplementary affidavit.
So that before the next date of hearing.
Yes, much before the next year.
Because this can't be a reply because
Supplementary affidavit.
Absolutely. Grateful, milord. 8 May, lordship is fixed.
Kindly allow me to appear virtually, Mano. Item number 18.
Dosto.
Item 18.
My lord, I beg to appear, my lord. Kindly allow me to appear virtually. 18. My lord, pursuant to my lord's order dated 19 December, extension order, my lord, dated 6th of February 2025, my lord, publication has been effected on 21st March, my lord. And 4 weeks time, my lord, yet to be,
So it is complied with.
it is complied with, my lord, time to file any caveat or time was granted 4 weeks. It was published on 21st March.
It is called for from the department on service of on issue of citations and lodging of any caveat. The report shall be submitted in this court on or before the returnable date. Let the matter appear in the list on 15th May.
Grateful.
19.
This matter, there was action to find the report by the registering service. That report has been filed. So with regard to this, the PLA matter has been disposed of. And with regard to, there is an issue that whether after filing of the bond, that I have to deposit the fixed deposit in the name of the registrar, or you said the mark lien. That was to be considered by your lordship.
Yes, there was a lien.
The FDs were marked lien by the registrar. Now he is doing in every case. Now the question, the report has been submitted by the registrar insolvency, which has been submitted to me also, where it says there is no provision under the law, under the ordinance rules, that the marking of lien is not permissible.
It is the discretion of the registrar. Number two, he is also
রিপোর্টটা
not,
কি ছিল?
also not passing any order to that effect so that I can come before your lordship.
Have you furnished bond?
Yes, everything has been done. Then the FDs have been also returned. I had raised an issue that whether that marking of lien in favor of the registrar is permissible.
No, you have furnished this bond. This is bond.
Everything has been done.
So FD should be returned to you.
If this has been returned, now I had raised an issue whether that can be done by the registrar. He is in each and every matter, he is asking for the FDs to be kept as a lien. That is the question before your lordship, whether the registrar can do it. The registrar insolvency report says he cannot. There is no provision.
Let me discuss. So I won't like to put any order.
Lordship, kindly mark the matter to go out of the list, my lord, because the matter has been, my lord, the grant has been issued and my lord, we have also received the FDs.
So let it be disposed of, treated as disposed of. Bond is furnished by the petitioner. Letter of administration has already been issued. The application stand as well as the probate proceeding stands disposed of.
Okay.
I beg to appeal for the petitioner, my lord. This matter and amendment was allowed by your lordship, and there was a direction, my lord, to publish the gist of the citation in a Hindi newspaper as well as state of West Bengal. The address which has been amended in the state of West Punjab, so probably a report has been filed by the department to that would be a national daily newspaper, subject to what the department have informed us.
Peruse the report of the assistant registrar dated 17/3/2025. In modification of the order dated 20th February 2025, it is directed that paper publication will be made in one national English national daily, another daily newspaper in circulation in the state of Punjab.
National, vernacular national, because national English and also a national vernacular.
National vernacular.
Any, I mean to say, well, there are certain newspapers which has been.
Since it is stated that the person is living in Punjab, so any newspaper which is in circulation in Punjab, in the national daily, and another will be published in a newspaper which is in circulation in the state of Punjab. Let the matter appear in the list on 12 June.
This is my application for revocation of grant. Your Lordship, by an order dated 20th February 2025, Your Lordship had given directions for filing affidavits. My learned friend has been late in filing.
Out of time, Lordship, by 10 days. Kindly accept.
This is Leo.
Lordship, my learned
Yes,
friends
my
are in
affidavit in
opposition.
Would you like to file any reply?
Yes, my lord. Kindly give us 2 weeks time to file.
Affidavit in opposition is filed on behalf of the executor. Full stop, Mr. Court, the learned counsel appearing for the petitioner seeks for accommodation to file affidavit in reply. Full stop, the same is allowed. Affidavit in reply shall be filed on or before the returnable date. Let the matter appear in the list on 16th May.
Lordship, just one more indulgence. The names have been wrongly recorded. I am being led by Mr. Shobhoshachi Chaudhary. In the last order, the names of the parties appearing
The
for...
names of the correction ta kore deben.
May I just hand over a copy of who's appearing for whom? Petition at the right. I'm grateful.
22.
My lord, kindly allow me to appear virtually.
Yes.
My lord, my lord sought for a report from the register insolvency. In the meantime, my lord, we applied for the ad valorem duty court fees. My lord, it is receivable within, my lord, a week from the stamp vendor. And as soon as it is, my lord, available to us, we will deposit to the
There is no
department.
caveat.
No caveat.
An accommodation is sought for by Mr. Betal to pay ad valorem court fees, which is pending. Time is extended till 16th May.
Grateful.
Matter will appear in the date.
16. Grateful.
23.
For the petitioner, my lord, this is an amendment application. The amendment was allowed. My lord, the amendment was carried out. My lord, on the last.
Is J1
J1 is
amendment application. Then it should be disposed of.
All the formalities have been done. The amendment has been carried out, my lord. On the last occasion, my lord has called for the report.
There is some discrepancy of the address.
Was, my lord, it has been amended. It has been rectified.
This report has came yesterday only. The report of the learned register in insolvency in charge, dated 9/4/25, be kept in record. A copy of the report may be handed over to the learned counsel for the petitioner for doing the needful, for perusal and taking necessary action. Adjourned to 16th May. 15th May. Check it. Copy will be given to you.
24.
My lord, I appear for the plaintiff, my lord, in this matter, item 24. My lord, this application has been substantially heard by the coordinate bench along with another application which is GA2 filed by the defendant for revocation of leave. It's a section 92 suit. My lord, but the interim order, lordship has the urgent determination of Justice Rao's bench today. The interim order is expiring today. So if lordship so pleases, lordship can extend the interim order and my lord, thereafter, my lord, let the matter go out of the list so that my lord, we can have it again placed before Justice Rao, because both parties have substantially argued it there.
No, it is
I believe
Justice Rao.
Yes.
So this is only for the reason for passing extension.
Extension lordship passes and thereafter, my lord,
And I'm releasing it. Of course, this is not my determination.
Yes.
No,
No,
my lord.
this is my determination.
My lord, may I just say this? My
Now
lord, I
lordship
think, my
has
lord,
the determination.
my lord, today, because Justice Rao is not there, your lordship is having the determination. So, my lord, for that, we are seeking an extension of the interim order. If your lordship can kindly do that.
Even then, this is under my determination, 22 suit.
Yes.
My lord, yes. Now, my lord, both the parties, my lord, are, my lord, with humility, my lord, Karan doesn't take me amiss, because, my lord, substantial arguments have been
All
done
right,
before
I'm
Justice
releasing it.
Rao. So then your lordship will, after extending, kindly releases it, my
Right.
lord, so that we can take steps, man.
Ad interim order, when it was passed?
23rd September 2022, and it was, my lord, extended time to time.
23rd September.
And 2022, and this is the last extension, my lord. 18th of March.
Ad interim order is extended for 15 days. The suit is released along with the application is released from this court to place before the bench of Justice Krishna Rao, who heard it substantially, on the prayer of the learned counsels.
Grateful.
Very grateful, your lordship.
I think Mr. Rai has more or less completed. I had to give a response to
No. Mr. Rai is yet to.
No, I wasn't completing, so that is why, my lord, we made this prayer, my lord. I'm very grateful.
25.
My application. I'm already enjoying an interim order. Now it's after affidavits.
Can you come at 2 p.m. after 2 p.m.?
After 2 p.m., I have some difficulty.
GA10, what is GA10?
GA10 is my application for an interim order. Your Lordship, my lord, after hearing me at the ad interim stage, has given me a protection. After that, my lord, affidavits are complete. My lord, this is a matter, my lord, where I have inherited a property, a large property from my grandfather. My grandfather, then father, and then me. Now, my lord, the property had been leased out by my father to the defend number one. Defend number one has now, my lord, sought to perpetrate fraud on me and has caused a deed of conveyance to be executed for sale of major part of that property. It's a 38 katha property. Out of the 38 kathas, 30 katha was sold at a meager sum. 8 katha, which is the balance property, that, my lord, was leased out to the defend number 4 by the sub-leased out by the defend number 1 to the defend number 4. The lease expires in 2028. The defend number 4 has filed a written statement. In the written statement, the defend number 4 has said that the defend number 1 is desirous of extending the lease for a further period of time. That sublease which the defend number 1 had created in favor of the defend number 4 is also subject matter of challenge. I am saying that right now, since the the trial of the suit is also going on, and my lord, the property should not be further encumbered. So therefore, there should not be any further encumbrance of that 8 katha of land by defend number 1 in favor of defend number 4 for a further period after 2028. There is no urgency also. Your lordship had protected me, my lord, by an order dated
11th February.
the present order. My lord, had 15th January, your lordship had protected me also, my lord. Your lordship sees the order. The instant application GA10 is filed praying inter alia for an order of injunction restraining respond number 1 from dealing with any part of the
Yes,
suit
it was
property.
given.
Yes, my lord. So now, my lord, the matter has to be heard out and find the interim order. I'm going to ask for the confirmation of the interim order.
Yes, what it says.
On the face of it, your lordship will see that the application is premature. Because, my lord, the anxiety of the plaintiff is that the deed of sublease may be renewed. My lord, the deed of sublease will only be renewed when the original term expires. Now, my lord, kindly see, my lord, page 6.
May I? If my learned friend says so, I'm okay. If he says that it will be renewed only after 2028, then, my lord, my application, I had nothing to say. Since there is an allegation that he's
Then
going to
lordship will
extend it
discontinue the
immediately.
interim order and dismiss the
No, with
application.
the undertaking.
No,
with
there
the
is no undertaking. my lord.
No, either of these.
No, I cannot give an
How can
undertaking.
he claim both?
No,
He's
no.
saying that it will
See,
be
I'm
extended
saying
only in
no. I'm
2028.
saying that the cause of action for filing of the application is premature. Cause of action of the application filing is premature. Kindly see, my lord, order 39 rule 1.
Well, in case if my learned friend is starting, I have my lots to show, my lord. If your lordship,
Then come on some
I'm
other
ready, my
day.
lord, I can start. my lord.
Then come some other day.
well, can it be any day after 21st? Then, my lord, 21st of April.
First week of May.
Well, the interim order also has to be extended,
Yes.
my lord.
Adjourn to 5th May. And
My lord,
interim order is
should we
extended
also
till
come
date.
with a notes of argument, my lord? Short note.
If you
one
like.
minute. Obliged.
Yes, and one more.
This matter on 12th of March. The suit for
Yes.
witness action.
Yes, that should
Was to
continue.
be kept on, it was kept on 9th. It didn't appear yesterday.
Oh.
Or should fix it immediately.
Yes, my lord.
The suit
I'm
will
on that
appear in the
item.
list for witness action on 9th. It was fixed yesterday.
Yes.
Didn't appear in the list.
But may it appear before the hearing of the interlocutory application?
Yes, my lord, I'm at item.
21st was fixed.
But yesterday it was the suit was due to appear in your lordship's list for resumption of the cross
28th
examination.
April
Yes, 28th April.
Oh, obliged.
for witness action.
For witness.
For cross examination of PW.
Yes. This is item number
25.
29.
29.
Very good.
26 to 28. I will take up after recess. Who is your other side?
Lord, I'm the other side. I'm being led by Mr. Bag. Lord, he's appearing virtually.
Milord, I am appearing. Milord, I am opposing this mentioning for the only reason they were aware, Milord, when this day is coming to an end. And Milord, kindly see the last few orders in all the Milord extension of this interim order we have always opposed. Saying this order cannot be extended, should not be extended. Milord,
Practice before Justice Rao. The day when the
indeed, and on this prayer, Milord, this matter was fixed.
it has to be mentioned. Today it was if Justice Rao was sitting, I would mention before Justice Rao.
Where is the record? রেকর্ড না আমি অর্ডার করবো কি করে রেকর্ড আনো then it will appear in the supplementary list.
Milord, will it appear today, Milord?
Yes, only I am in charge today.
Lordship.
Means there is urgency, prayer for urgency is there, it is to be to come into list.
Milord, we will also indicate, Milord, that there were other orders, Milord, when the matter is taken up, the other orders where we have always opposed this extension, Milord. It is not the first time that we are opposing the extension, and that is why, Milord, the matter was
All
fixed.
right, let it appear in the list, supplementary list.
Lordship, I'm deeply obliged.
Thank you, my lord, Justice Rao's determination. Interim order granted by your lordship. My lord, it's expiring today on the returnable date.
এটাকে দিয়ে দাও supplementary list এ দিয়ে দাও
And it is three matters, my lord. If you want, CS 173 CS 173 CS 173
Item number 6.
Yes, Lord, I appear for the plaintiff, Lord. I was addressing.
let me see the plaint. Have you filed any compilation?
I have filed a compilation.
Compilation to them.
Compilation of exhibits. I find there are two exhibits missing in the compilation. Exhibit 1 and 2 are missing.
Oh.
Check it.
Yes. We did. And there's the index. No, the index says exhibit 2 A, B, C, D, E, F, G, H, I, J. Then it starts from exhibit 3.
Oh, it's my mistake.
So exhibit 1 and 2 are missing, which are in the judge's brief.
Yes.
Which are in the judge. And as exhibit A is concerned, one extra page has gone in. Page 25.
Yes, I am not relying on that page.
He said on the last. I have also filed my written note.
Exhibit B is the draft one.
Exhibit B, Lord.
B is the draft which was sent.
Yes. Yes, exhibit B is the draft.
Yes, the draft agreement.
And final is?
The final, your lordship will find that, my lord, exhibit D, page 21 of the judge's brief of document. And it is also there, my lord, in the compilation also.
Compilation is not page.
Yes, in
14.
compilation, it's at page 14.
14 pages শুরু হচ্ছে email covering.
Exhibit D, yes.
Yes, that's
তখন যে আসছে তবে তাহলে সেই
তাই আমি দিয়েছি
হলো
So there was a draft agreement which was subsequently amended or modified to give a final form.
Yes.
This final form is Exhibit D. Now you are the plaintiff. You are plaintiff.
Yes, I am for the plaintiff.
Your point is that this appointment was not absolute appointment.
Yes, the appointment did not take effect.
Take effect. So you're not liable for any money.
Yes, in fact, my lord, I had given him advance consideration. Since the employment agreement did not take effect, I am entitled to return of that consideration. This is the subject matter of my plaint case.
And Mr. Mitro's claim is the service remuneration for service rendered.
Yes.
On the ground that agreement actually started.
Yes.
Took effect.
Now, my lord, there is a caveat to it. So far as Mr. Mitro's claim is concerned, kindly takes his written statement and counterclaim file. My lord, the heads of his counterclaims.
Which is missing here?
My lord,
That is exhibit 1 and 2. Exhibit in the compilation. 1 or 2 times.
Compilation. Is there any compilation of pleadings?
No.
Written statement.
Yes. Lordship kindly takes my lord page 11, paragraph 29. Kindly see, my lord, he has claimed a sum of rupees 2.21 crores. Now, my lord, the heads are
2.21, not 2.21.
Yes, my lord, 2 crore 21 lakh 38,000.
Total 2811 so and so.
Yes, my lord, that's 2 crore 81 lakh 16,328. 238. 2.81 crores in total. Now, my lord, kindly see the breakup given. Balance payment payable on appointment. But there is no clause in the agreement under which he is entitled to any balance payment. Now, the first argument is that the employment agreement did not take effect. If it did not take effect, he is not entitled to any payment.
For this reason, for same argument, these monthly payments by remuneration are not payable.
Yes, but that's the first reason. And the second is, there is no document on record to show that he has rendered service. There is no document on record. But he has disclosed an invoice. The invoice, Lordship will find, my lord. But kindly takes, my lord, his invoice that he has disclosed, which is, my lord, at page 56 onwards of the judge's brief of documents. 56.
All the exhibits, these are only exhibits of plaintiff.
My lord, yes, I have missed out 2 documents in my compilation.
If exhibits are ABCD, defendants are 1, 2, 3.
Yes, in fact, my lord, the exhibit.
Both exhibits are there. Yes, exhibit 4 is
Yes,
there.
exhibit
3D are there.
If Lordship
Only 1 and 2 got missing.
Yes, if Lordship sees one of the compilation also, page 58 of the compilation, which is exhibit 4.
So you refer to the compilation only, not both.
Yes, I'll refer to the compilation only. But this is a document of 5th of November 2019. But this document, as per the defendant's witness, was sent by speed post. But there is no document showing that the letter was delivered to the plaintiff. Along with this document, he sends the invoices which are at page 59 and 60. My learned friend has
no receipt.
No receipt. Now, my lord, even if your lordship sees, my lord, the document at page 59 and 60, my lord, kindly see the amount demanded. Kindly see, my lord, page 59 is for business consultancy services as per engagement letter of 2nd of August 2019. Kindly see, my lord, the total claim. It's 1 point.
When this 550 lakh was paid?
3rd of August 2019. Immediately after execution of the
August
2019. The employment agreement is 2nd of August 2019. And on the next date, the payments were remitted. But if Lordship sees the compilation.
So according to you, when this bill was raised on 3rd August, 50 lakh had already been paid.
Yes, I had given him advance. But because the agreement was like this.
No, it is there. Less advance received 50 lakh.
Yes.
So balance payable 127.
Yes, that he is claiming.
What is this 27 lakhs?
My lord, that he claims on account of IGST, 18%.
It's 2 lakhs.
No, it's 27 lakhs. 5টা zero আছে.
No, no. Page 58.
Page 59.
Page 59.
Compilation.
Sorry.
But I do not understand the demand made in the invoice at page 59, which is the 3rd of August 2019. But total he has claimed 1.1 crore 27 lakhs.
Deducting the amount already received.
I do not understand, my lord. The next document, which is at page 60 of the
Monthly
compilation.
remuneration 15 or 10?
But my lord, remuneration was not fixed at all. But this is
No,
the
no, he has claimed certain things.
yes.
1 crore 80 a year. Exhibit D.
No, if he is claiming the entire amount for a year, how can he raise an invoice for the next month? My lord, page 59, if your lordship sees, the document is dated 3rd of August.
Now, your let me understand, Mr. Mitro. Your calculation is fees for month of August, September, October, November, 17 lakh 70,000.
My lord is looking at the written statement.
Yes.
Yes, I just.
Excellent.
Yes, written statement I've asked for first is balance 1 crore.
All right, that I understand. But fees per month 1770
1770.
each month.
Yes, each month. This is my lord.
But if lordship adds 17 lakh 70,000 for August, September, October, November, it's coming to 70 lakhs 80,000.
She will kindly take exhibit D.
It cannot be 1.27 crores.
Just a minute. So for each month, month of
15 lakhs.
August, September, October, November is 17 lakhs.
It is 15 lakhs.
15.
Because if lordship sees exhibit D is 1 crore 80 lakhs per annum, which is coming, it is written in each monthly installment of 15 lakhs. The remuneration was 15 lakhs a month.
Plus GST.
Yes. Yes.
That's why 1770.
Yes.
Yes.
Very well. Even if I go by the figures mentioned at page 11 of the written statement, 17 lakh 70,000 he is claiming for August, September, October, November. If we add up, it's coming to 70 lakhs. There is no justification of the invoice at page 59 of the compilation wherein he has demanded 1.27 crores. Kindly see the invoice at page 59 of the compilation, 3rd of August 2019.
GST has added GST.
Yes, he might add GST, but kindly see the balance payable. 1 crore 27 lakhs. What is
1 crore 50 plus GST 27 lakhs?
Yes.
That has gone wrong, I must say. It
If
is
the invoice is correct, then the demand is incorrect.
So it is 2 lakh 70.
But
It has
he
gone in
cannot,
as-
he cannot indicate any figure at
All
this
right.
point of
Let
time.
let us assume that it will be corrected.
No, Mulad, the invoice is, first of all, Mulad, there is no valid
Please,
demand.
please. Let us assume it will be corrected. If there is a wrong. Now you come to first point. What you are arguing is whether he is entitled to, whether right or wrong, whatever. There must be some figure and whether he is entitled to that one.
Yes. If I, my lord, show your lordship that he is not entitled to any amount, correction, incorrection will be an irrelevant issue.
Yes.
My lord, the employment agreement did not take off. That is my first point. Second, my lord, the invoices were not delivered to the plaintiff. So there is no valid demand made. If no demand, then he is not entitled to any money. Now your lordship sees again, my lord, page 11 of the written statement. My lord, serial number Roman 6. Page 11 of the written statement, which is the tabulation of his counterclaim.
Page 11.
Page 11 of the written statement.
Yes.
Kindly see, my lord, paragraph 29. My lord, the particulars have been provided. Kindly see Roman 6. Reimbursement for expenses for travel, food and lodging. He has claimed, my lord, 58,770. There is no document and record showing that he has traveled. He has, my lord, eaten food in a restaurant. He has, my lord, stayed in a hotel. his lodging expenses. There is no primary document disclosed. The entire
Particulars are not given.
nothing, no primary documents given. So claim not proved. Last, your lordship will see the last amount, the severance fee that he has claimed as per clause 14 of the agreement of 2nd of August 2019. He has demanded 59,77,468. Now, my lord, he is not entitled to this sum in terms of clause 14. Kindly now, my lord, sees the agreement. Kindly takes the compilation. Kindly takes the compilation. Lordship will find the agreement. It is Exhibit D, page 14. If Lordship will straight away come to clause 14, which is as internal page 5 of the agreement. Kindly takes page 18 of the compilation.
Yes, I
Clause
got
14. I'll just place the clause 14.1. Engagements pursuant to this agreement and or any further continuation thereof will however be subject to satisfactory performance of the responsibilities assigned to you as per terms contained therein. I'll pause here for a while. He is entitled to sums under the agreement provided his services are satisfactory. No document has been disclosed to show that his services were satisfactory. First and foremost, he has not rendered any service. If at all he shows, or if he makes out a case that he has rendered service, I have to be satisfied for him to be entitled to any payment. Next, your lordship sees, in case your services are found not up to our expectation or not required for any reason, your engagement pursuant to this agreement will be terminated by ML, that's me, without any notice and or without assigning any reason. The decision of the company shall be final, conclusive and binding on you in this regard. However, in the aforesaid case of termination, you will be entitled for such compensation incentive which accrue to you till the date of the aforesaid termination in accordance with para 17 herein below, along with additional agreed fixed severance fee of 50 lakhs. The clause is, the clause will only operate so far as his demand for severance fee is concerned when the employment agreement is terminated by me. Kindly see how
severance clause is applicable only, it's one-sided provision. This severance agreement,
Yes.
this severance clause
Yes.
is only one-sided
No,
possible.
but he is entitled to the incentive or compensation which accrue to
Those
him.
he are entitled to.
Yes.
But on completion of the whole tenure.
Yes.
So far as severance fees is concerned, separation fees, fixed separation fees of 50 lakhs, that you will have to pay to ML. This is one-sided.
Yes, I am ML. Kindly see, however, in the aforesaid case of you.
That's what I'm saying.
Yes.
You will get it.
I will not get it. He will get it. He will be entitled to compensation. He will be entitled to compensation incentive which accrued till the date of aforesaid termination in accordance with para 17 herein below, along with additional.
However, in such case, you will have to pay ML on the date of such.
You is ML is he.
Yes, I am ML.
I understand. However, in that case, you, that means you.
Yes, you means him.
Yes, he will pay ML on the date of termination fixed separation fees. ML will get 50 lakhs.
No,
That
no, I will not get any 50 lakhs. If I terminate his agreement, I'll just give an example. 2nd of August 2019, for the sake of argument, I'm considering
14.2 says you will not be entitled to terminate this agreement.
Yes.
First part, and thereby discontinue providing your services to ML in accordance therewith before completion of 2 years.
Who is the defendant?
Yes.
Yes, Thomas.
Yes, yes.
Thomas.
Correct.
In case you will like to terminate this agreement and discontinue providing your service to ML after completion of 2 years.
Yes.
This is a situation when it will be terminated after 2 years.
Yes.
But before 2 years, what will happen? You will be entitled to for such compensation incentives which will accrue to you till date.
Yes.
That is after completion of 2 years.
Yes, 14.1 provides for a situation before expiry of 2 years. 14.2
Yes.
provides for a situation post expiry of 2 years. Here, my lord, since we are in 14.1, since my lord, the agreement, my lord, since my lord, he is running a case that he is entitled to severance fee, which is only provided in 14.1. I am only showing your lordship the guideline or the requirements of 14.1 of the clause. 14.1 says, my lord, he, my lord, is employed, he is inducted as a consultant. My lord, if I find that his services are unsatisfactory, I'll terminate him. Now, on the date of termination, whatever is required, his emolument, his fees, his service charges, but that will be paid to him along with a severance fee of rupees 50 lakhs. Now, my lord, my humble submission before your lordship today is that this quantum of 50 lakhs will only arise, or my obligation to make payment of this 50 lakhs will only arise when I terminate or put an end to this contract.
On the basis of 14.1, he is claiming 50 lakh.
Yes, but 41, he will not be entitled to this amount.
Yes, I understand your argument.
Because I have not terminated the agreement. It is he who has indicated his willingness to put an end to this contract. It is only when the company
How can you say his willingness is there?
Yes, kindly see, Mula, there is a letter on record.
Exhibit C.
No, I'll just indicate the letter. Yes. But this letter is dated, Malad,
Page?
30th of December 2019.
Page?
Yes, Malad, 30th of December 2019. Right, it's there in the judge's brief, there in the judge's brief of documents.
Come in terms of this compilation. I'm looking the compilation.
I think, Malad,
it is not there.
It's 3C. Yes, Malad, exhibit 3C, page 56 of the compilation. Yes, 30th December 2019. This is one of the defendant's email. But kindly see the last paragraph. I would therefore look forward to a gentle separation, valuing all the good moments spent together. Look to hear from you soon. Well, this is his intention to put an end to the contractual obligation, provided that the employment agreement took off. If I terminate the agreement, the defendant will be entitled to severance fee of 50 lakhs in terms of 14.1. But here, Malad, the case is that defendant has chosen to put an end to the contract. If that is the case, then he is not entitled to 50 lakhs under 14.1 of the agreement.
Yes.
Now, Malad, his last limb of argument that this is a contingent contract. Now, Malad, he being a defendant, it is only in one case that he is entitled to enforcement of the contingent contract. Kindly takes, Malad, section Malad 33 of the Indian Contract Act.
Yes, so tell me.
The reason why I am showing your lordship section 33 is because here, Malad, the contingent event did not happen. Because the other four experts, lordship will recall, did not join simultaneously with the defendant. Now kindly see section 33.
So the contract did not materialize.
Yes, but agreement was entered into, but his employment did not take effect.
Yes, it did not materialize.
Yes, it did not materialize. Hence, my lord, he is not entitled to any
It was still executory contract.
Yes, now lordship sees section 33, but his argument was that he is entitled to under section 32, but lordship sees section 33 once. Contingent contracts to do or not to do anything if an uncertain future event does not happen can be enforced when the happening of that event becomes impossible and not before. So kindly see, this is a contingent contract to do something to do something is ensure the appointment of those other experts. Now, to do or not to do anything if an uncertain future event does not happen. It did not happen in this place, can be enforced when the happening of that event becomes impossible and not before. Mr. Mitra ought to have made out a case of frustration for him to enforce this contract under section 33.
It is not a frustration. It's not a case of frustration.
Yeah, he has not made out a case of frustration. Hence, he is not entitled to any enforcement. Because under section 33, he could have only, because I have shown your lordship documents and evidence that there is not a document on record wherefrom the defendant has been able to establish that the 4 other experts join the plaintiff. So if those 4 other experts did not join the plaintiff, then my lord, the uncertain event did not happen. Now, if the uncertainty did not happen, then my lord, the situation is covered by section 33. Section 33, my lord, in that case provides that he is only entitled to enforcement provides the event has become impossible.
And any benefit taken should be returned.
Yes, he has to, because the agreement executed, agreement did not take effect because those other experts did not join. He was awarded, my lord, but he was made over advance consideration.
I got your point. I got your argument. Mr. Mitra, anything to reply?
Yes, my lord, I have prepared a preliminary note. But may I file it?
Come with the final note. So if you
is on the fine, this is only relating to the. I have prepared it issue-wise for your lordship's convenience, and I've given the page numbers.
Come one note, not multiple notes.
One note.
My note is the final note.
Yes, come with the final note.
No, then, my lord, I'll just add the judgments in this.
Do that.
Very well.
If there are a number of notes, then I have to hanker for this.
Very well. I'll in one
I have
comprehensive
to be
note.
in the bush.
Very well.
When you look, how long it would you take to?
I will oral argument so far is I'll cite few judgments just to show that even Mr. Mitra's argument was that I did not file any additional written statement so far as his counterclaim is concerned. Counterclaim is like a cross suit. He becomes the plaintiff, I become the defendant. Now, in that case, the principles will apply that even in an undefended suit, the plaintiff has to prove his case. He has not proved his counterclaim because there is no document and record to show to prove these particulars at para 29. Second, my lord, my documents which are there on record.
How long would you take?
I'll take 15 to 20 minutes on the next day.
How long would you take to file the written statement? What should be the next day?
Final notes, not written statement.
Final
notes. Yes.
28th, if lordship keeps
28
it.
देखो तो.
Or 29th, I think lordship has some difficulty on 28th.
29.
29th.
Hard in part. Adjourned to 29th April. That day I will reserve.
Yes, and I will give a 5 minutes answer to this.
Great.
Thing is not very complicated, so it should be finished.
Yes.
I'll reply on the very same day.
Very simple point, whether the agreement took place or not.
Yes.
This much.
Yes.
There are no other nitty-gritties,
Yes.
no other complication.
Grateful.
Grateful.
We
We can share the judgments prior. Note
Yes, I'll give him a small list of the cases that I wish to do. Revise for
advance note.
Item 26. My application. In fact, 26, 27 and 28.
26,
27 and 28 are
Yes.
all being heard analogously. Parties are more or less the same. My lord, in your lordship's
what is
last
G,
order,
then GA1?
GA1 in item number 26 was for appointment of a commissioner. Your lordship has appointed a commissioner.
Hmm.
It was only kept today for framing of issues.
Commissioner for?
My lord, for recording the evidence of the plaintiff's witness because he is an, your lordship
Without
remembers.
framing
he is-
issues, evidence.
Yes, my lord, lives in UK. He is an old man, 80 years or so, wheelchair bound. Your lordship has appointed, but had kept the matter, my lord, fixed for framing of issues. My lord, I am carrying the issues of both parties because the defendants have stopped appearing, which is why, my lord, your lordship will see the next two are undefended. 27 and 28 are undefended. Now, my lord, what has happened in the meantime? My lord, what has happened in the meantime is one of the parties in CS 76, which is original filed before this honorable court, which is item number 27. One of the added defendants, defendant number 4, has died. So
you
we
have
have
to file
taken out a GA, we have taken it out. It's appearing in your lordship's list. That is GA number 12 in item number 27.
GA number 12 to dekhi.
That is for striking out the name of defendant number 4 and consequential amendments. I have indicated, my lord, date of death and, my lord, what is the nature of the amendment required in the proposed plaint. My lord, very small, only cause title and 3 paragraphs. Your lordship will see, my lord, I have given.
Where is the date of death?
My lord, the date of death I have pleaded, my lord, at paragraph 10, 8th February 2025. And, my lord, the relevant documents I have disclosed at paragraphs at pages 13 capital A, 13B, and 13C.
Defendant
Shunita
number
Devi,
4.
Yes, my lord. Defendant number 4, my lord, who is Shunita Devi Sharda. She is the wife of defendant number 2. And, my lord, no.
The legal heirs are there.
My lord, husband is there, defendant number 2, and no question of, my lord, any other heirs being brought on because she was not even a partner. CS 76 is for dissolution of a partnership firm. Plaintiff and defendant number 2 are the only surviving partners. The reason why we had added defendant
So it will come order 30.
Yes. Now, my lord, only expunging of the name from the cause title, my lord, proposed plaint I have disclosed at page 14 onwards. Your lordship will see page 15, name has to be struck out. Again, my lord, at paragraph 11, some amendments need to be done because her name has to be indicated
GA
with
12
since
of 25 is filed. For deleting the name of defendant number 4 because of death. Full stop. The defendant number 4 died on 8 February 2025. Which occasioned amendment of the plaint. Amendment of plaint. Accordingly, prayer A to
Prayer
of the master summons be allowed.
Great. And F, my lord, also.
Huh?
To re-verify and reaffirm. A to F.
A to F.
Grateful.
Allowed GA 12 of 25 stands disposed of accordingly.
My lord, that apart, my lord, your lordship will have to frame the issues in EOS number 3. EOS number 2, I'm sorry, which is item number 26. 3 in a 2.
EOS 3.
I'm sorry, my lord, EOS 3, I stand corrected.
US 3 is contested.
Yes.
What is GA 1?
They are not appearing all.
GA 1.
Well, that was for appointment of commissioner. Your lordship has appointed.
That is done.
Yes, but your lordship had kept it pending to consider the report of the commissioner.
All right.
Even that date has to be extended. It expires, my lord, I think, on 7th April. Day before.
Next para
2 days back.
Time is extended to file advocate commissioner's report till 10 June. Next. Plaint dekhi.
Well, these are my suggested issues. I've handed over a copy.
Yes.
76 is framed already. Oh. Well, not in 76, only in EOS 3. EOS 76 is undefended. In EOS 3, they have filed written statement, and before the learned court below, they had filed these suggested issues. They have filed nothing before this honorable.
Where is the suggested issue?
My lord, I've just handed over my suggested issues. And my lord, this is the one filed by the defendants before the learned court at Shuri. It is part of the records in the Shuri court.
ইস্যুটা আমি চেম্বারে বসে করব। On the basis of rival pleadings, the following issues are framed. ওটা চেম্বারে বসে দিয়ে দেবো।
And my lord, may I file my judge's brief in these two EOSs?
Judge's brief of document be kept in record. File be kept in record.
Grateful.
এইটা পাঠিয়ে দেবে, এটা written statement-টা পাঠিয়ে দেবে। এটা চেম্বারে ইস্যু।
And your lordship has extended the time for the report of the commission.
Yes, 11 June.
Very good.
11 না 10 কবে বললাম? 10 June.
10th June. Grateful.
Item number 29 to 32.
Mr. Mukherjee, one by one argument.
My lord, in this matter, my lord had permitted amendment of plaint in the third matter, CS 1970 of 1965, my lord. The re-verification and reaffirmation of the plaint is yet to be carried out.
You are the plaintiff.
No, I am the plaintiff.
In that suit, they are the plaintiff.
CS 1970, my lord, kindly see the last order dated 13th March.
Reaffirmation and re-verification of the plaint, if not done, shall be complete on or before the returnable date. Let the matter appear in the list on 22nd April. Come, both of you come with the notes of argument. Things should be finished now. In all the four suits.
May I request, may we come back in the month of May, my lord, since
Very old suit.
and this guy, my half a size of documents.
You have to argue on the point of law, whether there was breach of contract.
Absolutely. I bow down to your lordship.
Second thing, whether the goods are of actual quality,
To
merchantable
reach
quality.
the points of law, I have to, my lord, I have to refer
Some
to
kg
the
of documents.
refer to the documents and evidence.
Some kg of documents.
Some quintal, maybe.
And I have to hear that.
22 witnesses.
Come with the notes of argument.
I'll
তো ওটাকে ডেট দিয়ে দাও 15th May.
Item number
In the
33.
meantime, my lord was kind enough to direct the department to restructure the documents and to provide it to us. My lord, out of 22 witnesses, we got only 16 deposition of 16 witnesses. My lord, rest 6 will indicate in our letter, if your lordship kindly permits us, will indicate in our letter, rest 6 deposition be provided to
And
both
also
of us.
the exhibits.
And also the exhibits. Exhibits are
The exhibits as well as testimony of witnesses, deposition of witnesses shall be placed before this court. Most of the learned counsel shall be allowed to inspect those documents in terms of the original side rules.
and both the learned advocate on records be given liberty to communicate the department.
That is enough.
Will indicate which deposition are incomplete. Have not yet been given to us.
They will inspect and report.
Very, very.
The learned counsel shall inspect and inform the department in case of incomplete record of the same.
I'm great.
And in report if any part of the record is incomplete.
33.
I am for defendant number 2. Led by
Mr. Dotto,
a short person.
where is Mr. Ghosh? Mr. Ghosh? Okay.
Obliged, Your Honor.
34 and 35.
And for the plaintiff,
Mr. Shah was arguing last time, my lord. He's held up in the next court, my lord. He's addressing court number 41, my lord.
Next court.
Next court.
Passover.
He will
Or
take
another
time.
date.
Another date, because although Mr. Mukherjee is there, my lord, but my lord, since he was continuing, it would be better if Lordship hears him. My lord. Any date, my lord. He was expected to be here only after the next week, after the next week.
Skipping 16 and 17. Well, then answer me, what shall I do on those dates? I have to come to this court.
Yes, I will also come.
Then come on, argue on that date.
You know, still pass it. I can inquire from Mr. Jasa. I don't know whether he here or not.
Are you date bolo? এই মধ্যে হবে না 30th April is okay.
If I may pray for 23rd April, because my lord, Mr. Shaha is leading me, my lord, in another matter, my lord, which is my lord a fixed matter.
23rd April.
23rd.
Which matter?
My lord, another matter, partnership matter, he is leading me.
Maka.
My lord, the Sherajuddin and company. My lord, that is arbitration, my lord, section 37 appeal. Before my lord Justice Shorkar. It's a fixed matter at 10:30. So my lord, at 2, my lord, Mr. Shaha will be available hopefully.
Oh, he'll be available, sir. 23rd, you know.
23rd, my lord,
23rd.
he will come back.
Serajuddin.
Sherajuddin. My lord, that iron ore mining, that partnership.
That is past order. Oh, this is under 34.
37, my lord. 37 appeal under the Arbitration and Conciliation Act. Now, my lord, the other partners are also fighting. Are also fighting. Brothers are fighting.
Very good. That is good for you.
23rd, that. Keep clear.
That's
Now, one thing I need a clarification. Your point is that why did you terminate the agreement? Because first an agreement was executed, then you sent the other side, your other side is defendant. Sent an amended agreement. Amended agreement did not mention transfer of 50% share. Rather, it's in a different tune. So you terminated it.
no, my lord. It's the defendant who has terminated. I'm the plaintiff in the first suit. My lord, they have terminated it by way of an SMS.
By text
of
message, we
25th
terminated, which they do not dispute. Rather, they have disclosed the text message. It is part of their exhibit. So
Now that is to be shown me.
Yes, that is
Yes,
part of the
my lord.
exhibit. They
And
admit
my lord,
that.
we have shown it, my lord.
Repudiation is accepted by both parties.
Yes.
It's only a question of, my lord, after repudiation, what they chose to do. They did not treat the contract to be valid and subsisting. They accepted the repudiation, went on and sold.
Then I have to check the evidence. I have to check the evidence.
My lord, in fact, my lord, this is the issue, and I am led by Mr. Chaudhuri. He also submitted, my lord, that my lord, the agreement, under the agreement, the 100% shareholding by us was to be transferred to them by 30th November 2010. And my lord, the agreement says that till such time, 51% they will be retaining and 49% we will be retaining. So in any event, they had a majority, 51-49. My lord, now their case is 24th. Their case is we terminated because according to them, we have come up with a proposal for amendment saying that it should be 59 in our controlled by us and 49 controlled by them. My lord, which is not correct. In any event, our case
That
is
should you
That
should
is
not
the
show
catch. That
with
is the
evidence.
catch. The modification was to reduce me to a minority shareholder. Your lordship has absolutely
that
correctly
isn't
pointed out.
accepted.
Original,
51-49.
No, I have to see both the agreements.
we paid the earnest, undisputed, 1 crore received by them. They have appropriated. Now from 51-49, they have made it 49-51.
No, we did
So I am
not-
reduced to a minority.
No, what the document will say that. Document will say that.
Absolutely. My lord, the amended MOU is there, my lord. Story.
Let me see the documents.
They
Document
would
will
have
say.
transferred even the 51, if it is their case that the contract was not validly repudiated, they should have transferred, not done that also.
All right. Come on the next date.
Very well, Abhishek. Right.
Witness action, item number 36.
I am for the defendant, my lord.
For the plaintiff's lordship, I am being led by Mr. Shuddhu Shattu Banerjee. He has some personal difficulty.
Witness is there or not?
Witness is not there today because he had some personal difficulty. We had to change the entire schedule, lordship.
You are plaintiff.
I'm for the plaintiff, lordship. May I be permitted to submit the judge's brief of document, lordship?
Judge's brief of documents submitted on behalf of the plaintiff be kept in record.
And also the affidavit of admission denial.
Affidavit of admission. Issues are framed.
Issues have been framed, lordship. Issues
Long back, my lord.
Admission and denial of documents
I'm giving up.
be kept in record. On prayer of the learned counsel for the plaintiff, witness action is adjourned to
Lordship,
20th May.
20th, Lordship, I am not there from 16th. I'm personally not there, Lordship.
When will be available?
April 29th, 30th, my
No.
lord.
Three things are there.
My lord. My lord. Then in that case, my lord.
3 witnesses are there. 3 witness action on consecutive days.
2 witness action has already been done. Only 1 is left from our side.
On the give me the 20th, you will be not there. You want a prior date.
Later than that, Lordship. But the whole week will be holiday. I
Yes,
think
sir,
Mr.
2
Banerjee
weeks.
will
Then after reopening.
Reopening, my lord, after
opening any 29th, 30th. Or my learned friend.
May.
May must बोल रही हूँ.
Oh, May Mashe.
20th May.
Yes, Lord.
20th May बोल रही हूँ.
Acha, I was under the impression April. I'm sorry, Lord.
May.
Because 20th April is Sunday. Mr. Banerjee is here.
Yes, Mr. There's some personal ground here.
May. 20th May.
No, 20th. Week before.
Other matters are there.
I know, but if before then, if I get a week before, then my executor, at least my examination will conclude before the vacation. A week before that, if your lordship gives me, along with 20th of May, 2 days I'll take for
7, 8. 7th May.
Very good. Very good.
Great. Item 33.
Grateful, my lord.
First of all matter, item number 33.
Where is Mr. Dotto? I was hearing him. I was hearing you, sir.
My lord, on the earlier occasion, my lord, I had placed before your lordship the plaint and the written statement. The suit for, my lord, specific performance of a contract entered into, my lord, the original agreement was, my lord, between the plaintiff on the one hand and the defendants number 1 and 2 on the other. Now, my lord, the defendant number 1, the mother settled.
The daughter did not.
The daughter is contesting. So, may I show your lordship, my lord, the evidence of the defendant number 2? I shall come to the evidence of the plaintiff later on.
That is in page.
Kindly allow me.
It's a document. Deposition.
Deposition of, my lord.
Defendant number 2. Yes.
May I, my lord, hurriedly go through it, my lord, so that, my lord, I don't miss anything. Who is Shankarlal Sarkar, my father? Is your father alive? No. When did your father expire? In the year 1987. Can you tell before this court who were living when your father expired? I was living there with my father and my mother.
This living spelling should be corrected.
Yes, there are some, my lord. There are some mistakes. Then kindly come to the, are you 2 legal heirs of your father? Yes. Have you any brother? No. What was your age when your father passed away? Nearly 19. What was your means and livelihood when your father passed away? Rental income. Rental income of which property? 215 NSC Bost Road and 217 NSC Bost Road. My lord, these are the properties. My lord, suit properties. Were you independent and financially stable when your father expired? No, I was dependent on my mother, not on the properties. Do you know, Mr. So-and-so,
He was my father's friend as well as solicitor. How do you know him? About 2 occasions my father took me to his office. Since when did you know Mr. So-and-so? From about 1985. What right do you have in respect of these 2 properties? After my father's death, I became the owner of the property along with my mother. Can you tell what is the measurement of these 2 properties? Little less than 40 cutters. What is the nature of structure standing on these 2 properties? Outhouses, garages, partially 2-storied brick-built building, partially 3-storied brick-built building, and overhead water tank. Are these properties freehold or encumbered? There are some tenants on the properties. How many tenants are there? Did all these tenants pay rent? Pay you rent every month? Indirectly, I really do not know what she meant anymore. What did you mean by to say indirectly? They pay rent to the rent controller. Do you know the plaintiff? Only plaintiff number 1 I know. What about the other plaintiffs? When I received the writ of summons in this suit, at that time I got to know there were 3 other plaintiffs. How did you come to know of the plaintiff of the present suit? I came to know plaintiff number 1 when I went to Mr. Mondol's office on 5th August 1987. Are you aware of the fact that the plaintiffs are seeking specific performance of 6 alleged agreements for sale, allegedly executed by you in respect of your 2 properties, being premises number such and such and such and such? From the instant suit, I came to know that they have filed specific suit for specific performance. Have you gone through those agreements? Yes. For the first time, when the suit came up in the honorable court, I got to see the papers at that time. But kindly take note her stand in evidence. I shall again show your lordship the written statement. Before this suit came up before this honorable court, were you not aware of all those alleged 6 agreements for sale? Leading question though, yet no. Did you agree with the terms and conditions contained in those alleged 6 agreements for sale? Absolutely not.
Just a minute. Let me check written statement.
Yes. Now kindly look into the written statement. Written statement of the defendant number 2.
আছে আছে এখানে আছে।
But kindly come from paragraph 6, madam. May I place it?
I got it.
Lordship. And then paragraph 7. Now, vis-a-vis paragraph 7, my lord, kindly look into, my lord, her evidence or her reply to question number 28.
You refer to question number
28. In paragraph 7, our case is that she was induced by her mother. The defendant number 1 and her advocate so and so to sign several papers purporting to contain agreement for development of the two properties, etc. And in 28, she says, question was, can you explain the reasons or ground for your not accepting the terms and conditions of the alleged agreements for sale? Because my will was not there. I was coerced and was under pressure to sign those agreements. Then they allowed me to go through the papers. So her earlier evidence that she did not go through the agreement before, false. Question number 25 and answer.
25 and 28 are mutually contradictory.
Absolutely. I'm obliged. Then they allowed me to go through the papers. They did not allow me to read what is written there, nor I was allowed to show it to any other lawyer. And interestingly, I'll show your lordship, her evidence is that she has a cousin who is a lawyer. She wanted to consult the cousin, not a single letter. Not a single letter disputing the agreement or alleging that she was, my lord, induced or coerced to sign any document.
So according to you, it is afterthought.
Absolutely. Absolutely. Now, paragraph 7, she also denies that she received any consideration. Paragraph 7 of the written statement.
Received any consideration?
Yes,
Or
kindly come to
executed-
page 5. Page 5, my lord, paragraph 7. Second line from the top.
Yes.
This defendant denies that she received any consideration or executed any of the alleged 7 agreements out of her own free will or volition. This defendant states that the alleged agreements are illegal, unconscionable, invalid, not binding on her, and that she has duly avoided the same. I really do not
There is
know.
no counterclaim.
No. Then paragraph 8. This defendant reiterates that she never agreed to sell any portion of the said two premises to any of the plaintiffs. This defendant did not receive any part of the alleged earnest money alleged to have been paid by the plaintiff. This defendant states that she was compelled to sign the said alleged agreement under compulsion of the defendant number 1 and her advocate. Now kindly come back to the evidence. Question number 28 I had placed. Kindly come to question number 29. In answer to your earlier question, you had referred certain persons. Who are they? Can you tell their names? That was my mother, Mr. So-and-so, the developer, Mr. Pawan Kumar Tibriwala, were there, and there were some official staff in the chamber of Mr. So-and-so. Next, did you sign those alleged 6 agreements for sale freely, independently, and out of your own volition? No. There was an altercation with Mr. Mr. So-and-so, when he suggested that I should sign the papers because my mother had already signed them. I said that I wanted to show it to my uncle and his son, who is also High Court lawyer. On hearing this, Mr. So-and-so got very furious. He thumped the table and charged my mother by saying that, Miss Sharkar, please control your daughter, and said she is not listening to us. We are her elders and you are all wasting my time. Now, my lord, with respect, She is so close to the uncle and her son and his son, her cousin. Her cousin, she does not go report it and issues any letter. First thing, my lord, anybody would do is, my lord, protest. It was not done.
No general diary was lodged.
No, not a single document on record at least. Then kindly come to question number 33, where the draft copies of these alleged agreements for sale handed over to you for your reading or for your perusal. No, I was not given anything to read even after signing any copy of the sale agreement. Did you consult with any advocate or legal professional before execution of this agreement? I was not given any opportunity, as I said earlier. 35. Who did not give you the opportunity to read those agreements? None stopped that. I really do not know. None stopped that situation. All of them were there, watching me right of the corner of the room, with the back of the chair against the wall. I was getting very agitated because there was a very little hostile and violative, threatening kind of
Volatile.
atmosphere.
Hostile and volatile.
Volatile, sorry. Hostile and volatile, threatening kind of atmosphere in the room, that you must sign these agreements. Obviously, my will was not there. I was not it should be I was compelled and under duress because of my young age.
There should be a full stop here. Sign these agreements, full stop. Obviously, my will was not there.
Lordship.
It should start after full stop, I think.
Lordship. O should be capital, yes. Her mother was there.
I was not compelled.
It should be I was compelled. I can't take advantage of this. I don't want to take advantage of this. Then question 36, which situation you were referring to in your earlier answer? When they had taken me to Mr. So-and-so's office inside his room. Can you tell the said situation happened or occurred? When? Can you tell when the said situation happened or occurred? 5th August 1987. The same year my father died in January. Who made this situation of duress and undue things? Mainly it was the solicitor, and in support of my mother being silent, and Mr. Tibriwal was angry. Since when do you know Mr. Tibriwal? That day, Mr. Mondol's chamber on 5th August, when I walked into Mr. Mondol's chamber, he asked me, do you know why you are here? Then I said no. Then he showed Mr. Tibriwal to me and saying that this is Mr. Tibriwal.
Every place squashed was written as squashed.
Yes.
The advocate on record should take care of this.
I will, my lord. In fact, I will also personally check. Some corrections were made, it appears.
Not all.
Not all. একটু কারেকশন গুলো ঠিক করে দেখে করে ফেল রে ওদেরকেও দেখিয়ে
Her evidence was she was coerced, post coerced, put on fear on all these things.
Nothing to prove.
Now, what was your cross-examination?
I shall come to that. Should I correct it and come back, my lord? Because there are many mistakes.
Heard Mr. Mitro, the learned senior counsel, in part for further argument. The suit is adjourned to April 30th April.
Lordship.
Correction should be made in the statement of witnesses in the meantime.
একটা তো বড় ভুল আছে।
One day.
বলে এটা কি
Supplementary list.
পরে দেখো।
Item number 1, Rajat Kumar Singh.
Extension of interim order. Interim order is extended till.
Lord, I am objecting to such extension, my lord, for one primary reason. Lord, the interim order has been passed in September 2023. Lord, the subject of the interim order was the plaintiff's desire to participate in the club elections. Lord, for this precise reason, my lord, the learned.
State this before regular bench.
My lord, in that
No,
case,
the
my
order
lord,
is there. I will simply extend.
my lord, I have a GA as well. My lord, GA4 is there. My lord, my only prayer in that application is an innocuous one that
till 21st April.
My lord, will kindly hear
Today, this on.
Let the matter be placed before regular bench.
And interim order granted earlier is extended till 21st of April.
Yes.
My lord, may I pray for the extension if your lordship is granting this for a short time, my lord, for a week?
21st April, covering the vacation, coming week's vacation.
Grateful.
I am grateful.
Item number Sam M.
Extension.
Yes, my lord. Extension of
At interim
Your
order,
lordship, I'm appearing for the respondent number 2, your lordship. ROC.
at interim order is extended till 21st April.
my lord. Item 3, 4 similar matters.
Item
Same order.
Yes.
Same order. For the first time, Mr. Chatterjee, there is a big procession for Jainists in Behala
Biala? Oh, I was not aware of.
till 12. Very big procession.
Today there has been a breakage of fire in 6 Old Post Office Street around in the lunchtime. There was lot of chaos. There were so many cars being parked over there. The fire